Good morning. My name is Jim Townsend, and I'm the director of the Levin Center at Wayne Law. And I have the distinct privilege of kicking off this panel discussion this morning and wrapping it up at the end. But before I get started, I'm going to turn things over briefly to our host here at the National Press Club, Mike Friedman. So Mike, if you would say a few words.
Good morning, everyone, and welcome to the National Press Club. It is so fitting that my first welcome as president of the National Press Club, I was inaugurated last Saturday evening, is to those attending a forum sponsored by my alma mater, Wayne State University. We're so pleased to have the Levin Center here today and appreciative of the relevance of your discussion today. And I'm also proud to continue a tradition of Wayne State alumni in the leadership of the National Press Club. As some of you may know, Detroit news writer Dick Ryan served as president in 2001, and of course the pathfinding journalist Helen Thomas led the battle to break the gender barrier, which had kept women from joining the National Press Club as full-time members. I had the pleasure of serving with Helen at United Press International, and I know firsthand how proud she was of her Wayne State education, then known simply as Wayne University. The challenges that we face as journalists today are significant, and they cut to the heart of our Constitution and our democracy. They're bigger than any one of us. They are bigger than the National Press Club. The work we do here is for the greater good, and we do it, as President Kennedy said of the space program, not because it's easy, but because it's hard, because it serves to organize and measure the best of our energies and skills, because that challenge is one we are willing to accept and one we cannot postpone. This, we believe, is a singular moment in our history, and it belongs to all of us. Since 1908, the National Press Club has served as an indispensable platform to educate, to inspire, to empower, and to protect. On behalf of the National Press Club, I thank you for bringing your forum here. I ask for your commitment to press freedom here and abroad, and I applaud your discussion today about this noble experiment we all cherish called democracy. Thank you, and have a good forum.
Well, Mike, thank you for that wonderful introduction. I'm just going to say a few words about what we're here to talk about and about the Levin Center at Wayne Law. But first, I want to thank you all again for being here this morning. This is a forum that will discuss the emerging case law on congressional oversight, and obviously, with what's taking place on the other side of town, I don't think our timing could be much better. We are not here, though, to discuss impeachment. We are here to discuss the broader issues of congressional oversight, the rules of the road, the rules that apply to Congress when it conducts congressional oversight, when it seeks documents, when it seeks testimony. So I'm going to just briefly talk about Wayne State University's Levin Center, and then turn it over to my colleague Elise Bean, who's going to moderate today's panel. The Levin Center at Wayne Law is a center at the law school that was established in 2015 to honor the work of Senator Carl Levin. Senator Carl Levin was the longest-serving U.S. Senator in Michigan history. He served for 36 years, and the hallmark of that service was his leadership in bipartisan, fact-based oversight. He made that his focus, and he uncovered and investigated on a bipartisan basis some of the most important matters of public policy, scandals, things that were of great concern to our country over his career. And so the Levin Center's goal, its mission, is to promote and advance bipartisan fact-based oversight. You know, what is that? That is fact-finding, the ability of Congress to come together across the aisle and create a factual predicate for action. And in many ways, what is paralyzing our country and certainly the Congress is our inability to do that now. So we're here to talk about what the rules are that govern Congress's ability to gather information from the executive branch and from others, and to get a better sense of where the court is going. This is something that has been litigated for over 200 years, but very few cases have really provided us, very few opinions out there have really provided us a lot of detail and guidance on where this is all going until now. Now there are nearly a dozen cases that are going through the court system that will shed light on what Congress's powers are, what are the limits of that power. It is quite extensive, but it is not unlimited. And so what we're going to learn about today is where those cases are going, what is the court beginning to tell us about the direction it's going to take in that regard. So before I turn it over to Elise, I'm going to actually touch on something that Elise has taken the lead of in creating and actually spending countless hours in creating, and that is a website that summarizes and provides information about these cases. And it's oversightcases.org, and it is on the Levin Center at Wayne Law's website as well. And what it does is provide information on each of these 12 cases. And I'm going to just attempt to quickly go to that website and just give you just a brief flavor for what it does. So here's the website, and again, it's oversightcases.org, and it's also a link on the Levin Center's website. And as you can see, it's very straightforward. It provides information about each of the 12 cases. It provides the key case citations for those cases, and then it provides a list of issues, and I'm going to just touch on the issues just really quickly, because I think this is extremely valuable. It talks about a series of the issues that are essentially being discussed in these cases and speaks to key quotes from those cases and the appropriate sites so that you can get a feel for what these cases, what the holdings are so far at least in these cases is. So, the duty to investigate, the limits on the oversight authority of Congress, the discussion about the immunity of presidential aides, the access to tax and financial records, which is the source of litigation or the topic of litigation that's now before the Supreme Court, and so on. So I'm not going to belabor this. If you have questions about this, we can certainly bring that to the fore later. But please use this as a resource. It's something you should be keeping your eye on because we're going to be updating this on a continuous basis as these cases progress. And now I'm going to turn it over to my colleague, Elise Bean, who is the co-director of the Levin Center's DC office, who will serve as our moderator. And again, I just want to thank you all for being here, and I look forward to this discussion as much as all of you. Thank you. Thanks so much.
Well, I'd like to introduce our panelists. We have a very distinguished set of legal experts here. Andy Wright, to my left, is now a partner at K&L Gates Law Firm. His career includes working for the House Committee on Oversight and Government Reform, including a staff director of the Subcommittee on National Security and Foreign Affairs. He did 2 stints in the White House counsel's office. He was a professor at Savannah Law School. He's a founding editor of the online national security forum, Justice Security. And he's now in the private sector, at times counseling subjects of congressional investigations, including in the recent House impeachment proceedings. Next, we have Professor Victoria Nourse. She teaches law at Georgetown University Law Center, where she's executive director of the Law School Center on Congressional Studies. Her career includes working for the Senate Judiciary Committee, for the Department of Justice, and as chief counsel to then Vice President Biden. Early in her career, she worked for the Senate Iran-Contra Committee, and she also clerked for New York trial judge Edward Weinfeld. These days, she's also a television commentator on the impeachment proceedings for PBS, and will have to leave us at 11:30 because it just keeps going, doesn't it? Next, we have Professor Kirsten Carlson. She comes to us from Wayne State University Law School, home of the Levin Center. She teaches a course on congressional oversight, bravo, as well as classes on civil procedure and American Indian law. In fact, she's a leading authority nationally on federal Indian law and legislation. She's been a Fulbright Scholar, a recipient of a National Science Foundation grant, and was selected by students as Professor of the Year in 2017. Earlier in her career, she clerked for Judge Diana Murphy on the 8th Circuit Court of Appeals. And finally, we have Professor Jonathan Adler, who comes to us from Case Western Reserve University School of Law, where he teaches environmental, regulatory, and constitutional law, and heads their Center for Environmental Law. He has contributed to 7 books, as well as countless chapters, articles, and blogs on a variety of legal issues. He's testified before Congress over a dozen times, and his work has been cited by the Supreme Court. He's a founding member of Checks and Balances and a regular contributor to the Volokh blog. He's also a leading legal commentator on radio and television with appearances on PBS, NewsHour, NPR, and Fox News. Earlier in his career, he worked for the Competitive Enterprise Institute, and he clerked for Judge Sentel on the D.C. Court of Appeals. So, pretty impressive group, right? Our plan today is to go through 4 key cases now making their way through the courts. Each professor will take the lead on one of the 4 cases, describing its status and key issues, and then we'll open it up to the entire panel to talk about the key issues for each case. And later at the end, we'll also take questions from the audience. When we do, you'll have to wait for the mic because we are recording this and we're going to put it on the Levin Center website. So, let's start with the Supreme Court trifecta, the 3 cases that President Trump lost in the lower courts, but was able to get the Supreme Court to consolidate and take up for review. Andy.
Thanks, Elise. First, I want to thank Elise and the Levin Center. I've been so honored to have any association I can get with the Levin Center and all the great work they're doing. And I also want to thank the National Press Club for hosting us here. This was actually, the last time I was here was the last time I saw Chairman Cummings live, and that was an amazing event. So it's great to be back under these circumstances to talk to you about the trio cases that have been consolidated and are now pending for argument in March before the Supreme Court that all relate to the scope of congressional or, 2 of which relate to the scope of congressional oversight power and which constitutional bases those powers are grounded in and how far they can reach. So the 3 are Trump versus Mazars, which is an accounting firm that has provided professional services to President Trump and his associated businesses, family members, et cetera. Trump versus Deutsche Bank, and Capital One, which relates to financial services provided to President Trump and various affiliated parties. And then Trump v. Vance, which we're not going to talk about as much because it relates to a state grand jury subpoena for similar records and it doesn't really encompass the congressional power issues at present, although there are some common issues at play. So the first, just to give you a sketch of those 2 congressional oversight cases and how they're sort of similar but also different in terms of the nature of the congressional investigations at issue. In Trump versus Mazars, it is really an investigation that comes out of Michael Cohen's testimony before the House of Representatives, which was, sort of adjunct to the Mueller investigation. It wasn't the Russia thread of that investigation, but it resulted in Cohen's testimony before the House in which he discussed a number of financial issues related to President Trump's prior dealings with an alleged mistresses and other financial activities. And during that testimony, he made some allegations against the president that related to potentially, altering or overemphasizing various financial assets, et cetera, which could impact the financial disclosure statements required by government employees, including the president, to sign, and other issues that Congress has an interest in, especially the my old committee, the House Oversight and Reform Committee, which has primary jurisdiction both as a matter of legislative authority and oversight jurisdiction over the Government and Ethics Act and other related matters. So they commenced an investigation, and they sent ultimately a subpoena to Mazars. They were not getting very far with the president himself in terms of obtaining documents, and they subpoenaed one of his accounting firm to try and obtain records relevant to the Cohen testimony. And just so you know, by way of background, the case law involving non-presidential clients of financial institutions and accounting firms has been very pro-Congress in the past. And Elise worked on the Backpage.com investigation in the Senate side, and there was the Fusion GPS litigation that related to the Republican-led House Intelligence Committee and antecedents to the Mueller investigation. that in both cases, folks that were at these firms objected to documents being provided to the government, to Congress, and in both cases were fairly quickly run out of court. And so in this context, it's framed in somewhat a similar way, with the president being the real party in interest, the professional services organization being the one receiving the subpoena, but it's the president, right? And it's got all the political ramifications related to that. And so it just takes on a different cast, and obviously I think the Supreme Court wants to have its say related to that. So at the district court level, the president lost, and then it went up to the Second Circuit, to the DC Circuit. The DC Circuit, the president lost again, although there was a spirited dissent in that case by Judge Rao. And then now it's pending before the Supreme Court. Switching to, and then I'll go into the sort of substantive clusters of issues here in a second. The second case, Trump versus Deutsche Bank, relates to more squarely the Russia investigation that was going on in the House of Representatives, and related to the Mueller investigation, parallel to it. And in this case, the committees on financial services and intelligence issued subpoenas to the banks that President Trump had been engaged in largely prior to his service as president or being a candidate, and wanted to find out information largely focused on potential money laundering issues, conflicts of interest, potential sources of leverage over the president related to investments in his businesses. And that had become an issue during their investigations. And there, again, they went up this time it was in New York, one in the Southern District of New York. The committees won at the Second Circuit level, again, over I would say, less spirited dissent, but a dissent that wanted to have a remand for further proceedings in its entirety to create a bigger record, and then now that's pending before the Supreme Court. So now, I just want to talk for a second about the issues that I think are sort of really in tension here, and we can get into specifics about the different cases in the Q&A. But the big ticket issue here is the scope and limitations of Congress's investigative power. And at the top line, there are a couple of different sub-issues there. The first one is, so clearly there's congressional investigative power to find out about legislation, things that they might want to legislate about, things that they have already legislated about to try and perfect their laws, make it better. It's, they have the oversight power for the same reason they have a really big library, so that they can learn things. It's the epistemology of legislation. But what's a little more difficult is, A, what are the limits on that power? And then B, are there additional powers that augment it? And specifically, I'm talking about the informing function discussion. And so there's been some case law language that suggests that they're independent to the legislative sort of proposed or actual legislation rationale, that there's an independent power for Congress to investigate in order to provide a check on the executive branch and inform the public about the workings of government. In other cases, that type of activity is sort of subsumed underneath the legislative purpose one. So it's like one of the rationales for the importance of their legislating power. And in another one, it's kind of got independent status. And so those are the that's in tension in this case as to whether or not Congress could, just putting aside whether they're considering a piece of legislation or potential legislation, go out and say, well, we want to expose misconduct because that's good for democracy. And that's part of our job under the Constitution. I think that's very much in tension. And then the second sort of line of tension there, I would say, is how do either of those two rationales for congressional oversight power play with impeachment power? And to that extent, that comes into question when the congressional investigative activity is sort of coextensive with potential exposure of criminal conduct. And there's a long history of Congress engaging in oversight investigations that uncover all sorts of criminal conduct, and large history of referrals for criminal law enforcement, and sometimes it's hard to even see a real daylight between the sort of legislative investigative scope and a potentially a criminal investigative scope because of the subject matter. For example, in these cases like money laundering. If Congress wants to legislate against money laundering and they're investigating cases of money laundering, that's going to look very much like the same scope that a grand jury might be looking into in money laundering cases. But the question is, in this case, when it involves the president, especially, does the impeachment power almost, and this is sort of the Rao dissent argument, does the impeachment power almost divest Congress of the ability to have that parallel criminal activity coverage in its traditional oversight functions when the president is the one who might be involved in the alleged misconduct? And I think that's very much in tension in this case as well, in these cases as well. And then there's a procedural piece, which I actually think could take on real importance in front of the Supreme Court, which is under the House rules, it's pretty clear that a committee can issue subpoenas and have the authority to do so under the House rules. How the Constitution provides House sort of plenary authority to establish its own rules. But the question then turns on what authority is required for that subpoena power to have the full weight and force of the Congress's power behind it. And the question here is whether or not specifically there need to be sort of a particularized, in this investigation, we're authorizing this committee or other body within component of Congress to issue subpoenas about these matters, versus under our House rules that we adopted at the beginning of the session, we've delegated power to particular chairmen, some of whom have to get, have unilateral authority to issue subpoenas in consultation with the ranking member, and others who have to get a committee vote. Is that sufficient external to the rules of the House to have the full sort of weight of the House behind it? And the reason I think that could take on real significance is if the Supreme Court wanted to rule in favor of the president but not totally upset all the prior case law, they could potentially explore that procedural rule as an off-ramp, I think, without sort of completely upsetting the traditional notions about legislative oversight power itself. So that's one I want to keep an eye on in general. The last piece I'll just say, and then I'll stop, is the role of the courts and in dispute resolution of this nature itself, I think, is at issue. And the courts have generally been pretty loath to want to referee the disputes in separation of powers disputes, especially in congressional oversight. I think they've been much less concerned about sort of making rulings in Congress's favor when it's addressed private parties. These cases sort of are in between. They're a hybrid. It's not really a separation of powers case because it's not the president's official conduct at issue. It's private, his role as a private business person, private candidate for office, but it's also the president, and there are incentives that could affect the presidency related to this case. And so as an adjunct to that, I would say the preferred method of resolution of these types of disputes has traditionally been the accommodations process, which Congress asks for information, then demands it, and the executive branch resists, and then at some point there's negotiated compromise, and Congress gets most of what it wanted, usually, sometimes all of what it wanted. But in this context currently, first of all, we've been operating under divided government for quite some time, quite frequently, and that's putting a strain on that kind of, those kinds of incentives. Second of all, this particular White House, unlike, I would say, the Obama administration, the Bush administrations, the Clinton administration, has taken a very categorical view that we're not going to engage in an accommodations process. We're going to say that the legislative purpose itself is lacking or is invalid on Congress's part, and we're not going to participate at all, which in this case is sort of calling the courts into the fray in a way that they're very uncomfortable with, and I think also is, I would say presidential power is kind of like holding sand. If you squeeze it too tight, it comes through your hand. If you hold it too loosely, it falls out of your hand. And this one's been very tightly squeezed, and so I think you can see in some of especially the Second Circuit opinion, there's a discussion about how the White House's sort of categorical refusal to engage in accommodations is sort of forcing the court into the fray in a way that they might be uncomfortable with. So with that said, I'm happy to talk about any further topics on this and look forward to hearing my colleagues' thoughts on these cases and the ones they're presenting.
Well, I think the bottom line there is that there are a lot of issues in these three cases, a lot of important issues that are going to affect congressional oversight for generations to come. So this is a very important set of cases for us to think about. So I'm going to sort of talk about some of the things that Andy did so we can unpack them a little bit more and get comments from the rest of the panel. So let's start here. One of the big things that all three cases, especially the two involving Congress, talk about is whether the president has absolute immunity from congressional subpoenas. The president has taken the position that he can not only not be indicted while in office, but he can't even be investigated while he's in office. And I want to ask all the panelists, how likely is it that the president is going to prevail in the Supreme Court with that kind of approach? And in addition, one of the cases says, well, when we're talking about presidential immunity, what does that mean? Does it mean it's not just for the president, but it's for his family, his businesses, and even his associates? There's one case that talks about that. So panelists, why don't we get some comments from you about some of that, the presidential immunity issue?
Want to start with me?
Sure.
I think given the existing Supreme Court case law, if they follow that, that there's almost no way that they're going to hold that the president is absolutely immune. They didn't hold that against President Clinton, Clinton versus Jones. They didn't hold that in Nixon. So I think they were. I also just think that the whole idea of absolute immunity, judges like to apply it to themselves, by the way, I think it's sort of contrary to the whole notion of the rule of law. And of course, in Clinton, they said President Clinton wasn't above the law, and President Nixon wasn't above the law. And this president has engaged in behavior that has not given him necessarily a feeling of the presumption of regularity, which the Supreme Court often gives presidents, a benefit of the doubt. So I don't think they're going to start anew. I do think the case raises some interesting questions. I don't think they'll go down Judge Rao's line on impeachment. Because that pretty much, again, immunizes the president unless there's an impeachment inquiry, which means we'll have many, many more impeachment inquiries. So to the answer to the question, the general rule, I just want to emphasize what, Andy said, which is, don't forget that since 1927, and even during the McCarthy era, right, when these investigations were looked down on as dangerous, the Supreme Court affirmed the right of Congress to subpoena witnesses, and that is not something I even put in my casebook because I thought it was so well established. What's to say? But guess what? Now it's a big deal. So I think it's great for the Levin Center, which I applaud and thank for inviting me here, and it's great for all of us who teach about Congress. I'm happy. I want them to resolve this, and I'll talk about this a little bit more, particularly with the McGahn case. Bob Bauer and I agree that being in the White House, you want this actually resolved because it lays the rules of the road for negotiation. In some ways, that is a favor and the silver lining of the cases.
Professor Carlson?
I agree with what Professor Nourse has said. I would be really surprised if the court came down and held that there was this absolute immunity and wasn't also very careful about kind of telling us where the limits are, not just across like the family members, but also, and I'm sure Professor Nourse will talk about this, thinking about it in terms of kind of the vertical application down the executive department. I think that, but that's assuming that, we're following the old law. I mean, I think that's the assumption, is that the old law is still good law. If we're following the old law, the answer here is really easy. But I also think that what the administration has done is presented an opportunity to the courts to come up with a whole new set of laws. And I think that is something we have to think about, because if that happens, then it's a question of what does it look like and how does it affect the balance of powers? How does it affect the separation of powers? How does it affect government accountability and transparency? I think Andy's completely right. Sorry, I should call you.
That's fine.
Call you Mr. Wright or Professor Wright.
Yes, sorry.
Andy,
Sorry. But I think he's completely right that there's this question that is pervading all of these cases, which is, what is the role of the courts here? Do the courts have a role? Do we want the courts to have a role? If they don't have a role, then what does Congress have to do to enforce the subpoena? And is it willing to take those actions? But I'm sure we'll talk more about that as we talk about the other cases.
Professor Adler?
Yeah, so I agree that of these cases, the Vance case should be the easiest, and think it would be very surprising if the court thought there was any sort of absolute immunity. I do, though, think that it is likely we will see on those questions an opinion that does lay out things that lower courts should consider to protect against the nightmare scenario of vexatious investigations. It is certainly true that the White House has done many things that undermine the presumption of regularity. There's an argument that has provoked a response which is also somewhat irregular. And I do think the justices will be concerned that there is a hypothetical scenario where every DA or attorney general in a jurisdiction that is of the other party of a president might start thinking, oh, these are ways to kind of nip at the heels of a president we don't like. And so I would not be at all surprised for, in lots of these contexts, for us to get remands with rules of saying, look, there is no absolute bar here, but there are sorts of questions that a district court should ask. And there are little bits, that raise questions. I mean, the claim has been made that the demand in the Vance case looks awfully like the congressional subpoena, and one would expect them to be different because one would think the interests of a local DA are different than the interests of Congress if what's being pursued is, in fact, the very legitimate and very serious local interest in enforcing local laws that were committed in the president's private capacity before he became president. And so I do think the court will be sensitive to those sorts of things. The other point I'll just note kind of across the board here, I think a real question in the way the court is going to, one thing to think about in how the court looks at a lot of these questions across the board is how formalist the court is versus how functionalist it is. And this is, a recurring theme in separation of powers context. Is the court thinking about the types of powers that branches of government exercise in very clearly defined, rigid boxes, or is it taking a more pragmatic view about how the system as a whole is supposed to operate? And when you look across separation of powers jurisprudence, there are cases that are very clearly formalist and some that are very clearly functionalist. There are reasons to suspect that there is a majority on the current court that wants to view these sorts of questions in a very formalist way. And I think that does put on the table things like, if an investigation is asking these sorts of questions that are more appropriate for impeachment, should Congress have to be willing to say that's what they're doing? And if one looks at, for example, Judge Rao's dissent in the Mazars case, she points out that the memoranda that came from the committee never uses the word. And we went through a long discussion here in Washington about whether or not the House was having an impeachment inquiry or not, which suggests that there are political consequences to openly saying, yes, impeachment might be on the table. And it would not surprise me if the court were to say, that's the way the system is supposed to work. We're not a check on the impeachment power. The only check on the impeachment power is political. And so that all we are going to require is if an investigation bleeds into the sorts of questions that are properly dealt with by impeachment, Congress just has to be willing to say it, right? The wolf has to come as a wolf. That would not surprise me. And that would, in the end, not give the president much protection because Congress has been willing to say they're doing an impeachment inquiry, and if going forward, you have to delegate to the Oversight Committee power to engage in predicate investigations that could be the basis for opening a more formal impeachment inquiry, well, then Congress will just get in the habit of doing that. But I do think that is a potential off-ramp for the court to not fully resolve the question, address it in a formalist way, which I think will appeal to a majority of the court, and just say, look, we're going to make the political actors be more open about what they're doing. And so I think that's something to pay attention to when we hear our arguments.
Sure.
I just wanted to throw out one issue, which is, I think that I didn't spend any time on the immunity issue because I think I just don't think that's going anywhere. But related to it is, what powers does the court see itself having to referee these disputes? And I think that's a very related issue. And what's really interesting is I think the cases, the Second Circuit and the D.C. Circuit seem to have a very different view of what power they have over in relation to a congressional subpoena. So, in the Second Circuit, there was the view that we can pare it down. We can say that there are certain things in the subpoena that were a little bit too broad, and we're going to do a little bit of supervision of that subpoena by having a privilege log and having creating some windows of time for people to object to certain documents coming over the transom if they have certain types of sensitivities contained in them, or it's too broad. Whereas I think the D.C. Circuit, and this is true when I was working on the Operation Fast and Furious litigation, which was related to the contempt citation against Attorney General Holder when I was in the White House, it was very categorical. It was like, well, either Congress had the right to look into this matter and the committee was authorized to issue the subpoena, and if so, then basically give everything up, versus, because we don't have the power to sit and referee and sort of do what we would normally do in a court on a motion to quash and manage, trim and line edit the document. I think that relates to the immunity issue because if the court is going to, which I think it will, reject the immunity argument, it's probably going to feel some need to reserve some power at some point to start doing a little bit of refereeing, even though it's outside its comfort zone, so that it can police this idea of potential continued harassment of an administration.
And in fact, one of the courts, the D.C. Circuit, sort of took an approach on balancing test, saying that we have to look at Congress's need to know versus privacy and harassment kinds of issues. And I'm wondering, how likely is it that the Supreme Court might go that way? Is privacy a constitutional right? Is it something that they would base a test on to say, well, the president, even while president, when you're looking into matters of his businesses, if you're looking into matters of what he did while he was a candidate, need to know versus privacy rights? What do you think?
So just jumping in on that, I think privacy is a constitutional right, and I think there is a core of privacy interests that could probably be on the reach of congressional investigation. I've written about that in a law review article about some critiques of Congress being a little overzealous sometimes about that. That said, I think it's a weaker argument for a president because they've stood for public office, and so I think there's a lot of case law that kind of language that supports that kind of view. But I also think your point raises another issue, which is the stakes of this particular trio of cases extend far beyond the president to Congress's oversight against all sorts of private entities, businesses, et cetera. Because if the court sort of makes a ruling that clips Congress's oversight power as limited by privacy rights in a robust way, then that's not going to just affect the president. That's going to affect companies and private individuals that have nothing to do with the sort of overtones of separation of powers or politics that this does.
Just saying this personally, not as a law professor, but as someone who worked in the White House, nothing they do is private. They can't even really have a private phone. They run for the highest public office and the most powerful office in the country. I've never known a candidate who, even for the Senate, who thinks there's much that's private about their entire family. That's called Oppo research, right? I don't think the court will, they might be tempted to do it, some of them, but other ones, because of the notion of right of privacy and abortion and all that, they're going to stay away from that, in my view. They might want to trim the subpoena, and they might want to have some power for that. I don't think we should assume, the slippery slope arguments are, full of logical fallacies, that all congressional subpoenas are vexatious at the beginning. I will say that I have been the subject of various, Vice President Biden was the subject of what I thought were various vexatious and extremely personal, and I can't explain them, and sort of legitimate. I mean, someone shot up his house when I was, or came near his house with a gun, and then all these subpoenas came regarding that. And we had to decide, some of the requests were kind of intrusive, and should we exert executive privilege? And we did what everybody has done in this town for a long time, which is negotiate, right? So what's going to happen in these cases is we're going to have a new baseline for negotiation, and I hope that there's some flexibility built into the court. I understand that there are some formalists, but the truth of the matter is, unless the court wants to get into this on a very regular basis, the more mushy their standard, the more litigation from AT&T as well as the president. And they're not really going to want to supervise all that, because this happens every second up and down Pennsylvania Avenue, oversight, because that's a huge function of Congress. The Attorney General goes up, oh, what are you doing on this kind of crime? Or every single department is subject to these requests. So are lots of third parties. So I'm hoping that there's a little play in the joints and this is where the court's own jurisdiction and its own capacity is going to come into play in terms of how much play. They may just punt and, with a sort of vague standard back to the courts, but I hope it's a delicate task. You want to have enough play in the joints to avoid vexatious stuff. On the other hand, you want to maintain, hopefully, a fairly deferential standard, the almost completely deferential standard that exists now to Congress.
And just to throw in one more factor is that the documents that have been subpoenaed here are not government documents. They're not subject
Yes.
to executive privilege. These
Yes.
are financial, tax, banking documents, to the extent that that plays
Yeah.
into this issue. And Professor Adler, is there anything else you want to say about this?
Yeah, there's two things. On the one hand, so it's going to step back for a second. Congress's oversight powers, at least from a formalist perspective, are necessary and proper to the execution of Congress's power to enact legislation. So this is why the question comes up, okay, how is this inquiry relevant to potential legislation Congress could consider? And one area which we'll talk about later, where Congress clearly has unequivocal authority to legislate with regard to the president's financial dealings, is the Foreign Emoluments Clause, which, unlike the Domestic Emoluments Clause, says the president can't accept them unless Congress says okay. So Congress clearly has the power to act with regard to the president's financial arrangements. And so inquiries that would inform that process are clearly on the table. The thing that's kind of on the other side and has came up in some of the oral arguments in some of these cases, and something that is worth just keeping in mind, is that when it comes to legislative oversight of any other part of the executive branch other than the president, him or herself, you are talking about entities that effectively Congress created. Right? Congress authorized the various departments. Congress gave them their powers. Congress gives them their money. Congress confirms the officers that run those. And so those are all legislative acts that Congress can do and will revisit. And so it has to be necessary and proper to those acts to be able to figure out what's happening with the things you created, right? You create a Department of Commerce, and if the Department of Commerce is doing squirrely stuff or spending money irresponsibly, or there's corruption or whatever, clearly Congress has to be able to investigate that. Congress does not create the office of the president. And so there is still this underlying question of, does that mean there is anything different? And if you, for example, look at Judge Livingston's partial dissent in the Second Circuit case, she raises some questions that I think are legitimate about, do these subpoenas really look like aids to legislation? So in one of her footnotes, she points out, the committee says they're using the president as a case study for potential legislation relating to financial records disclosure and the integrity of the banking system and so on. Okay, prominent case study, lots of reasons to think that there are things going on that Congress should look at, but then why would you only ask for the president's record beginning from the moment he became the nominee? That seems an odd date if what you're really looking at is a case study of the operation of the banking system as opposed to investigating the president as president. And is that the sort of thing that we should be willing to call an impeachment-related inquiry? It raises the question. I do think, and this is this last little point on this in terms of the court's ultimate power, I do think if the court went in a formalist direction on these questions, it would probably also say, once Congress invokes its impeachment power, we, the courts, have nothing to say. And under the other Nixon case, the case of Walter Nixon, that the courts might have something to say about whether or not this is necessary and proper to Congress's exercise of its legislative powers. But the courts might not have anything at all to say about how far is too far in an impeachment inquiry of the president, him or herself, and the check on that's purely political. So in that sense, the formalist approach may give the president very, very temporary respite in the instances of this immediately in this litigation, but in the long run would say, if Congress is willing to say this is what we're doing, it's entirely Congress's ballgame.
Well, I think we're going to continue to look at that impeachment question in our next case, because believe it or not, we just spent 30 minutes on that particular case. So I think we want to turn from presidential immunity issues to questions of whether presidential aides are absolutely immune to congressional subpoenas. So that's the McGahn case. And Professor Nourse, can you talk to us about that case?
Sure. The McGahn case is about there's a lot of talk in the press that sort of mushes all these cases together. I actually think that there's no way that the Supreme Court, I think that these cases are easier, the cases involving the tax returns. And I think congressional power to subpoena third parties hopefully will not be subverted. Otherwise, Congress will resort to sending the sergeant at arms over to people and putting them in their jail. That's not a good idea to make such dangerous, and I view them as dangerous inroads into what they have understood to be their power for hundreds of years, indeed since 1789. Nevertheless, let's talk about this case. This is something that bedevils everyone in the White House counsel's office, the VP counsel's office. Do senior advisors have to be called up to Congress? As having been a senior advisor and making ridiculously important decisions every 5 minutes of the day, even in the VP's office, I'd say, please don't make me go up to Congress. So personally, I wonder, is this a good idea? But what's going on now, as a scholar of this, I want to tell you the differences between this case and the only other recorded case that has ever been adjudicated. Because this president is has been refusing to send people up to Congress at all. And that's not going to last, in my view. This is a claim of absolute privilege not to even go up there. And there is existing law, but only one case in the D.C. Circuit. Why is this? Some presidents have complied. All the Nixon people went up there, Haldeman, Ehrlichman, they all went up. And other presidents have allowed them. Reagan had his own investigation. Allowed them, McFarland, all those people, they went up. So this is really a much more aggressive presidential defense against the actual testimony in Congress of senior aides, having already said I'm somewhat sympathetic to the idea that senior aides are extremely busy. They do raise different issues than the traditional congressional subpoena. Because most presidents in these cases have thought, oh, well, this looks like stonewalling, I don't want to do that, this hasn't come up to the courts. And we have one case called the Myers case. That was Harriet Myers, George W. Bush. It came out of the firing of U.S. attorneys. What did Harriet Myers know about Attorney General Gonzalez? when he fired some U.S. attorneys and whether he did that for political reasons. I'm not so sure that rises to the level of events of today, to tell you the truth, since U.S. attorneys are political appointees, but in any event. The Myers case was decided by a George W. Bush nominee, Judge Bates in the D.C. District Court, and he resoundingly rejected the notion of any absolute privilege to fail to actually appear in front of Congress in a lengthy opinion. And in the recent case of McGahn, and this comes out of testimony from the Mueller report where they wanted to hear from him because he was an important witness in the Mueller investigation, particularly with respect to the potential firing, and the president said, I want to fire Mueller, and McGahn said, I'm gonna quit. I sat behind him recently at someone and thanked him for that. That's what good lawyers do, when they do something that, they think is the wrong thing to do. So McGahn is told by the president, no, you can't testify in anything after the Mueller investigation. And he says, well, courts, you resolve this. And in the opinion by Judge Brown, an Obama appointee, she starts by saying, well, look, we've decided this here at the district court in D.C. Judge Bates, in 2008, decided that there is no absolute immunity. The president in this case made several arguments, some of which George W. Bush did not make. There are 88 pages of this over 100-page opinion which do not deal with absolute immunity. They deal with procedural defenses to even hearing the case. What are these procedural defenses? There was no subject matter jurisdiction for any federal court to hear the claim. That was not raised by George W. Bush in the Bates case. In the Myers case. There was no standing under three different arguments for no standing. Standing is you don't have a personal injury. There was no cause of action, which is there's no legal basis for the action. And then only finally then do you get to the question of whether there is absolute immunity for the president's advisors. The opinion is quite pungent about, in terms of its analysis of the separation of powers claims made by the president. And it's pungent. It begins with just invoking, well, we've already decided this, and we don't know why the president is even being more aggressive than in the prior case. And then she goes on to say, well, no, the president doesn't have absolute immunity under United States versus Nixon. If the president doesn't, how can his aides have it? Because they are invoking his immunity. Sure, they're busy, but Clinton was busy, and he had to go give his deposition in Clinton versus Jones. No president is above the law. So she rejects this absolute immunity. She's very careful, however, to say that this has nothing about executive privilege. Because what is required is, just like every private citizen, and this is how I would treat the Trump case as well, because I think he's no different from any private citizen in terms of his pre-presidential actions. But she spends a lot of time talking about the subpoena power in general. If Congress has any subpoena power anyway, right, they get to enforce it. Just like against any other citizen or any corporation like AT&T. Corporations go to the D.C. Circuit every day, and say, oh, I need to enforce the subpoena against MCI or et cetera. She treats it the same way, and she says, of course, they have to go and answer the subpoena. What they have to do is then, if someone asks you a question, what did the president say to you in that meeting? Then the president's lawyers can say executive privilege. The executive privilege question has to be adjudicated piece by piece, not in a blanket immunity, because almost no one has blanket immunity. What's interesting about this, so it doesn't really, as Bob Bauer has said in a piece on just security, I think, it's helpful now. At least we can get the absolute immunity thing off. For those of us who don't, think, actually, if you are the chief counsel, you're a really busy person, it's like, no, another thing to do. But that's just a functional consideration, right? I don't like either formalism or functionalism, and have written quite lengthily about this. I think they're both, they're falsely opposed, and they're neither of them are established in the actual Constitution or the text of the actual Constitution. But neither here nor there on the separation of powers, we can discuss that. I do think that it's good to have these things settled. It is the base for negotiation, because negotiation is going to happen no matter what, because this comes up so often every day. What I will note is, however, that I think what's unusual about her opinion is she's much more pungent. Judge Bates's opinion is very scholarly. His is much more pungent. She says the president distorts established separation of powers principles beyond all recognition in their argument that the court can't even hear the case, that there's no legal claim, there's no standing, and that there's no jurisdiction even, that no court could consider it. Some of this sounds in political question, but of course, even in the recent Zivotofsky case, the court ultimately, if there is a law to dispute, right, that the court, and there was only a question of law here. Do the president's immediate advisors have absolute immunity from Congress? And she's pretty forceful. She says, she says, they're claiming that the framers envision the president's purported power to kneecap House investigations of this is a quote, of executive branch operations by demanding that his senior level aides breach their legal duty to respond to compelled congressional process. She's saying he's stonewalling. These 88 pages of arguments are about stonewalling. Nor can I abide by DOJ's less than subtle suggestion that under our constitutional scheme, the legislature and the judiciary are both hopelessly stymied when it comes to addressing alleged abuses by the executive branch, such that ultimately the president wields virtually unchecked power. As a matter of law, senior level current and former presidential aides, including White House counsels, must appear before Congress if compelled by legislative process to do so. This means that such aides cannot defy a congressional subpoena on the basis of absolute testimonial immunity, even if the president for whom they work or works demands that response. And she makes some good arguments about, for example, McGahn is a former official. They keep saying they're busy. Well, he's not that busy anymore, right? He's just litigating. She has a wonderful hypo about decoration of the office of the president. And by the way, I disagree with Professor Adler. The office of the president is also created by Congress. It's funded by Congress. So what if Congress wants to redecorate and get the mouse out of the White House counsel's office? There is a mouse, because people bring food up there because they live there. What if they want to do some basic redecoration of all that stuff? She has a decor hypothetical. Can the president say, oh, I'm too busy for decor? You know, I like my little mousy. And the answer is no, there's no absolute immunity. So she says, basically the absolute testimonial immunity serves only the indefensible purpose of blocking testimony about non-protected subjects that are relevant to a congressional inquiry, and such an aide would otherwise have a legal duty to disclose. So she's setting a baseline against that, and that would be helpful in negotiations. So there we go.
Well, thank you for that pungent analysis. One of the things that comes up in that case, which I think is interesting, is if there is a right to immunity, who can assert that immunity? Is it the president? If his aide wants to testify, can the president override that aide and say you may not? Or is it up to the aide itself? And we sort of saw that in the House impeachment proceedings where the president had forbidden members of the administration to testify. When those people were subpoenaed, they testified. So, Professor Carlson, do you have any sort of comment on that aspect of this case?
Well, I think the absolute immunity argument is an interesting one, right? Because we've seen the president assert it. He's not asserting executive privilege here, which is his to assert, right? And so I think it opens the door to this kind of murky question of who gets to assert it, right? And does he get to assert it on their behalf? it seems to me that I don't know, because I think it's kind of a new foray, right? We haven't seen that many claims of absolute immunity because the assumption was that if there was a question, then the president would exert executive privilege. I hope that the court clarifies here and it does what we seem to expect it to do, which is say there's not an absolute immunity, so the question you've asked doesn't matter anymore, because the answer would be no one can assert it. But if they do uphold it, then I think you raise a really important question as to who would be able to assert it and what would it look like. And I don't think we know.
I agree the absolute immunity claim is not going to be accepted by the court, I'd be shocked if any court. I think, for example, when you listen to the oral argument in the D.C. Circuit in this case, there are questions that come back to something which I think is a theme today, which is the courts wondering about to what extent is this the responsibility of the courts and to what extent must the legislature engage in some form of self-help. And there's kind of two ways the legislature can engage in self-help. Right? One is if the executive branch is not being responsive, make obstruction of Congress and an article in an impeachment proceeding, which it regularly has been. And I would be surprised if the courts say that's it. You know, we have nothing to say about this. We're not going to bless this claim of absolute immunity. We're merely going to say that Congress has a remedy, and it has other remedies too. I mean, one of the things that we haven't put on the table yet is there is this possibility that the breakdown of regular proceedings in the other things that Congress does, the way it deals with, for example, legislating generally and appropriating, means that the sort of leverage Congress historically has been able to exercise has been kind of taken off the table. Right? Without a regular appropriations process, do you really have the ability to say, if this office won't give us the documents we're asking for, then we just won't fund this office? Right? Those sorts of negotiating tactics may not be on the table the way they used to be, and that may be a consequence of legislative dysfunction, and that then raises the question: to what extent do courts have to help Congress if Congress has less leverage than it did historically? Professor Nourse raised the issue of Congress's inherent contempt power, and there's a fun, interesting history of this. Historically, Congress would send out the sergeant of arms. I think the last time that was explicitly put on the table, I think, was with Fox Butterfield during the Nixon inquiry. That was the last time folks seriously talked about doing that to someone outside of Congress. And there was some use of the sergeant of arms for quorum calls and the like in the 80s. But the reason why I would be surprised if the courts say that sort of self-help means the courts don't have to act is that sort of scenario actually doesn't take the courts out of it, right? Because if you play out that scenario, what happens if the sergeant of arms is sent? Well, you know, sergeant of arms shows up at Don McGahn's office and right, and right, he could file writ of habeas corpus, or you could get a very old-fashioned tort suit. I mean, I point out to my con law students all the time how many cases like McCulloch versus Maryland, right, or cases like Luther versus Borden. The underlying facts are someone exerted force on someone else. And the way we have to understand whether or not that was legitimate is who actually had proper governmental power that they could use, right? Did Congress? And so at the end of the day, if Congress has to use its inherent contempt power, the courts are still going to be forced to either consider a writ of habeas corpus if McGahn's in the congressional jail, or if he physically resists and there's a question of, well, who in fact had the legal authority
He doesn't seem very aggressive.
So I would be surprised if the courts did that. But if you listen to the oral argument, there is this undercurrent of, okay, to what extent should we be involved? And there was also this interesting exchange where I think it was Judge Griffith, who worked for the Senate, asked, okay, why do you want this information? Is this moot? Or is impeachment for additional things relating to the Mueller report still on the table? And there's some back and forth, and ultimately the House attorney says, Congress might want to consider additional articles of impeachment, which I think is the right answer, and make this information available. The last thing I would just throw out is, I think one thing the White House might be concerned about is we don't know a lot about the contours of executive privilege and if it operates the way other privileges do. Don McGahn has already spoken about things the president did, not simply the firing of Comey. The one that I think is actually more serious is the Mueller report says that the president ordered Don McGahn to create false records for the purpose of misleading investigators, which in my book, if that in fact happened, that is clearly impeachable. That there is no inherent executive authority argument to even put on the table the way there might be with something like firing Comey or exercise of foreign policy, whatever else. The White House might be concerned that since McGahn has already spoken to folks outside the White House about those events, that like other forms of privilege, the privilege would be gone. And so I suspect that part of the reason they're taking this aggressive posture is they don't think executive privilege would work here the way it, say, might work with someone like John Bolton. I suspect the court might get that that's what's going on. That's the position.
And I'd like to interject one other thought as we continue the conversation. We only have a few minutes left, but what happens when we have one judge who said there is no absolute immunity? Now we have a second district court judge that has said there's no immunity. What happens if the White House just continues to ignore that?
Yeah, well, it raises a really interesting point, which is, so if you look at piggybacking off of the idea of what kinds of self-help or other constraints are there that are beyond judicial orders, right? One of them is legislative leverage, confirmations, things, where the executive branch needs something, and in order to get the thing they need done, they have to give over some documents, like John Brennan, confirmation, okay, we're going to finally give you access to some documents. If legislative processes in regular order are breaking down, that removes that one. I think that's true. There's also the idea of political polarization and shame. And what I mean by that, I don't mean it in the personal sense of shame, but that can affect these things too. But I mean it in the sense of if the political environment puts a premium on looking reasonable, then that's going to affect your behavior in terms of your public acts related to oversight responses because you want to look reasonable. If the political premium in the country is owning the other side, then that's going to have a very different set of incentives on the political side for whether or not you're going to cooperate with subpoenas. I think that's in play. And then the third one is the legal one, which goes exactly to what I think you're getting at, which is, we had the Myers case. How should the Myers case inform White House counsel's office? And that's something I personally struggled with in that office. And the fact of the matter is, I think the way we looked at it was like, we don't like it. OLC doesn't like it. We think, there is immunity for senior advisors, and there's a whole canon of OLC opinions to that effect. But that's the case. That's the most likely indicator of how the courts are going to rule in this case. And so we're going to look for opportunities to maybe push on that, find exceptions to that, put limits on that ruling, but we're basically going to conform our behavior to the assumption to a degree that that's what's happening. If you take a different view that says nothing at the district court matters and nothing at the circuit court matters, the only thing that matters is a Supreme Court ruling, and that's the only, that potentially will constrain our behavior, that also creates a very different set of behaviors that are going to be allowed in terms of the types of arguments you make and the way you respond to oversight. So I think we're just in a very different period than we were during the George W. Bush administration when Myers
And I
was
think the
decided.
judges have identified that when you talk about sort of that shame in the political sense, do you want to look reasonable? The judge in the McGahn case said she sort of accused the Department of Justice of being inconsistent. It says a lawsuit that asserts that a legislative subpoena should be quashed as unlawful is merely the flip side of a lawsuit that argues that a legislative subpoena should be enforced. In other words, the Department of Justice says we have the ability to go to court to quash a subpoena, but Congress does not have the ability to go to court to enforce a subpoena. That's inconsistent. And in fact, last night we saw a new pleading in the McGahn case where the lawyers in the impeachment proceeding said we have the president's lawyers saying we should be going to the courts to enforce subpoenas. Why isn't Congress enforcing their subpoenas in court because they've only done the McGahn case and not others, while in court the Department of Justice has said, we shouldn't be in court, this is the improper place to come to enforce these subpoenas, and you should use other kinds of leverage, including an impeachment proceeding. So any sort of comments or reactions to that problem?
Departmental arbitrage?
Well, that's what, I mean, the best argument that can be made is that the Department of Justice believes it has institutional interests that determine the positions it's going to argue in court. And so it's always going to argue, why does the Department of Justice always make aggressive standing arguments as a general matter? Because institutionally it feels that's the sort of thing it should do, and so that's not going to apply differently here. The president's defense team in the impeachment context are acting like a defense team, right? Which is any argument that's available that may have traction with the court, you make. And I think so. That's the best way to understand that conflict. I think the fact that the president's defense team is not purely private attorneys, right? Does include the White House counsel. Does make that harder to maintain, right? If it was purely, Jay Sekulow and private attorneys, people representing the president, as Donald Trump making the go to court argument, and then the government attorneys purely making the executive branch doesn't want these cases in court, that would be easier. I think having the White House counsel, in some respects involved in both, breaks that down a little bit.
I mean, it's not, I just say it's not unprecedented that the Department of Justice would just ignore a district court case.
Right.
Having argued, just to be fair,
Right.
because they're trying to establish precedent. And, it's the only reason how, as a 30-year-old lawyer, I got to argue anything in the civil courts, the civil appellate courts. So Reagan did this famously to try to establish an appellate precedent, right? So I don't think anyone should think it's so dramatic, although they are pushing very hard and harder than George W. Bush did, in my opinion, in the Gannon case.
Okay, let's move to our third case. We're going to shift gears from questions of immunity to questions involving congressional access to grand jury materials. So, Professor Carlson, can you help us with that case?
I'll try. So I want to thank Elise and the Levin Center. I think this is a really important and timely discussion that we need to be thinking about. So I'm going to talk about the Mueller grand jury case, and it grows out of the investigation that Special Counsel Robert Mueller conducted into Russian interference into the 2016 election. Basically, he was charged with looking into Russian interference and whether there were links or collusion between the Trump campaign and Russia in that interference. What this comes out of is actually his report. He submitted a confidential report to the Attorney General in March 2019, and then a redacted report was subsequently made public. That redacted report was redacted in part because of the grand jury materials that were cited in it. Those were what were redacted because we have, as a general rule, the idea that grand jury materials are protected and are not publicly disclosed. That said, just so you have some background on grand juries and grand jury secrecy, there are a number of exceptions to the protections for grand jury materials and their secrecy. And up until this point, one of the disclosures has been for congressional committees investigating impeachments or in impeachment inquiries. So the House Judiciary Committee requested the full report. The Attorney General's office refused to disclose the material. The House Judiciary Committee then actually subpoenaed for the report. And after that, they filed an application with the DC Federal District Court seeking the order under one of the exceptions in the Federal Rules of Criminal Procedure for disclosure under Rule 6E to obtain the material. And they asked for 3 categories of information. They asked for all redacted information from the Mueller report, any underlying transcripts or exhibits referenced in those redacted portions, and underlying grand jury testimony and transcripts and exhibits that related to specific individuals and events. For the first time, the Department of Justice not only resisted the disclosure, but they made the argument that Rule 6E does not actually authorize disclosure for grand jury materials in an impeachment hearing. So they basically have argued that Congress can't get these materials because Rule 6 lists all of the exceptions or all of the reasons for authorized disclosures, and it doesn't say anything about Congress, so Congress can't have this. And this is contrary to all existing law. There is no federal court that has ever refused disclosure to Congress in an impeachment hearing of either the president or a federal judge. So they kind of do this about face. In October, Chief Judge Howell ordered a focused and staged disclosure of the first two categories of material requested by the House Judiciary Committee with additional disclosures if necessary. And she basically says, these questions have been decided. What we're arguing over has already been decided. No court has ever denied disclosure of grand jury materials for use in impeachment. There are two DC district cases that actually mandate that this is the right answer, and she cites the Haldeman versus Circuit case and the McGeever versus Barr case. And she says there's no reason to think that these should not be disclosed, so I am going to order this limited disclosure. The Department of Justice immediately requested a stay, which Judge Howell denied, saying, look, you're not going to succeed on the merits. I'm not going to grant you a stay. The Department of Justice also appealed the case, and the D.C. Circuit agreed to hear the appeal and temporarily stayed the case. The D.C. Circuit has agreed to hear two issues on appeal, whether a Senate impeachment trial is a judicial proceeding within the meaning of Rule 6E3E1, and whether the district court judge properly exercised discretion in finding that the House Judiciary Committee has a particularized need for the withheld grand jury materials. The court later asked for supplemental briefing on whether the House Judiciary Committee could even bring the case. So this is kind of framed in a standing way, but there seems to be a justiciability question here too, and how the House's adoption of the two articles of impeachment in December affected the case. What's interesting is that the oral argument really focuses on these two issues that they asked for supplemental briefing on. There's much less about this question under 6E, and it focuses more on whether the court can actually hear the case and whether the case is still relevant given the jury, given the House's actions on impeachment. There's a third question that really comes up here that I think is also important, which is this question related to impeachment and Congress's power of impeachment. Is this something special? Do we treat cases differently based on the fact that they are related to an impeachment inquiry as opposed to just a legislative inquiry? And if that's the case, what are the differences? And Professor Adler has alluded to why there might be some differences here, but I think that's a big question that comes up here. In addition to the other two issues that the D.C. Circuit is focused on, and when it comes to the standing and justiciability questions, what they're really asking is what is Congress's role, or what is the court's role here? Can Congress ask a court to compel the executive branch to disclose grand jury information? And what does it mean to compel it? Part of what's complicated here is if you actually look at Federal Rule of Criminal Procedure 6E, it speaks of authorizations to disclose. It doesn't talk about compelling it. So if the D.C. District Court authorizes disclosure, what happens if the Department of Justice still refuses to hand over the materials? Do they have to resort to self-help? Do we end up with a subpoena? Do we end up with a sergeant of arms? What happens in that case? Do those powers of self-help differ in this case because it's an impeachment proceeding? I mean, the answer, or one possible answer when we think about McGann, if there's no standing in McGann with those subpoenas, is then there has to be an impeachment inquiry, but here we're in the impeachment inquiry, so what happens in that case? The other question that I think is really interesting that was raised in oral argument by Justice Griffiths is he basically just says, why does the House Judiciary Committee continue to even need these materials now that we've voted on articles of impeachment? And I think this gets to a timing question. It gets to a timing question that comes up in all these cases, right? We're talking about subpoenas that were issued months and months and months ago that we still don't have answers on, and how do those affect congressional investigations? And in this case, an impeachment proceeding. You know, and the truth is that the question isn't going away, right? The question is getting more pressing, right? As we are in the middle of a Senate trial, you know, at what point does this case become no longer relevant? When is it moot? And is it now? Is it after the trial? Does the House Judiciary Committee just keep saying, well, we might come up with more, we might impeach him again, right? There might be more articles of impeachment. We might have to do this again. I don't know, but it asks those types of questions. And it also gets to the question of kind of what is the harm to Congress in the impeachment process if this information isn't disclosed. So I think this case raises a lot of interesting questions. I think it fits nicely with some of the other questions that have been raised that are across these cases, and thinking about you know, Congress and its ability to get information. If Congress can't get information, can it fulfill its constitutional obligations for oversight? How does it affect that? But also these questions about what is the role of the courts? What role do we want them to play, or should they play here as well? So I think these are really important questions, and I really appreciate the opportunity to discuss them, and I'm sure you all want to hear what my colleagues have to say more than me, so I'm happy to
Well,
open
thank
it
you
up.
for that explanation. Again, a very complicated case with a lot of different issues that we will try to unpack a few of them. One of the issues that you talked about, I think is very interesting, that under 6E, it talks about authorizing access to information versus compelling. In the lower court decision, the judge decided to order the Department of Justice to produce these materials. What do people think about that in terms of what the appeals court might do, or even whether what happens if this should get to the Supreme Court? Professor Adler, do you want to start us
well,
off?
one thing I think that relates to that, which also came up in oral argument, is there is this question, which I guess is the last time we had to think about this related to yet another Nixon case involving Nixon's papers, which is whose materials are the grand jury materials? The Department of Justice has them, but there is an argument that the Justice Department has them really as a matter of convenience because it has the ability administratively to handle it, but that they aren't actually Article I documents. These are grand jury materials. These are really Article III materials. And if that's so, then it seems to me that if the judicial branch is authorized to disclose the material, it can certainly compel that whoever happens to be holding them to actually engage in that act. And so my own view is that if we think of these materials as ultimately the judiciary's materials, then that authorizing, compelling distinction in some respects collapses, and it doesn't create many problems. And I think that's certainly how I would approach it. I don't think we have much out there that actually tells us about how to answer that question. The other thing I was going to say is that there's a tension between the issues in this case and in some of the other cases, because if, as the administration has argued, Judge Rao argued in Mazars, that kind of once you put impeachment on the table, limits that might apply in other contexts don't apply anymore. Well, if we take that as a principle across the board, well, okay, fine. Congress couldn't get this material just generally because they wanted to know, but impeachment's on the table. So just as, now that they've invoked it, the arguments you might be able to make against Congress in other contexts should melt away here. I mean, so there's a tension between the arguments about not releasing the information here with the arguments in the other cases.
Yeah. I haven't fully thought about this, so this is real-time thinking, but to my mind, the word authorizing hits my ears in this context as in relation to the criminal provisions of 6E, that it is a federal crime to produce these materials in contravention of the secrecy rules in 6C. And so to me, authorizing language is less about sort of like custodial management authority to then decide not to produce them. I think the statute contemplates the justice not being a party in interest to release of the grand jury materials because it's a criminal defendant, and they are under an obligation not to violate that criminal defendant's, potential criminal defendant or investigated person target rights. And so it is commanding them to say, you now are able to do so without fear of criminal reprisal. So I'm not sure I even read it, and it's not inconsistent with the view, but it doesn't stream me as necessarily being as big a stumbling block.
And you also have an application process to the court, so that's different as well. Let's talk about another issue that you brought up about the issues of issuing stays pending appeal. In this case, do we have something justice delayed is justice denied if we miss the entire window for impeachment? Is that a problem? We have that in the McGahn case as well. The Department of Justice asked for a stay, the lower court denied it, but then they got it in the appellate court, and that has now been stayed for months. What do people think about that whole issue? Because if you're Congress and you want to get the information, you want to get it. You don't want to have a 6-month, 3-month, year-long delay.
I mean, a stay is coextensive with the merits on a lot of these issues, right? I mean, if for Backpage, for example, when the Backpage.com Senate subpoena, when they lost the stay on appeal, right, that resolved the litigation because they weren't, they had to produce the documents before they could make their argument on appeal. That was it. There was nothing left to fight over. And so I think in one sense, like, administrative stays are pretty important to preserve the legal issues for adjudication. On the other hand, I totally agree that the courts have got to be really mindful of the fact that House subpoenas expire after 2 years because it's not a perpetual body, and they need to really take that into account.
And it's interesting that the lower court will put out a 20-page decision explaining why there's no stay. The appeals court seemed to do it on automatic. You get one sentence with no explanation. It's just kind of an interesting thing in these cases.
But I think this is also a question where does the fact that we're in the middle of an impeachment proceeding matter, right? Because Mr. Wright is completely right. Normally it's a 2-year time window, right? We don't have a 2-year time window, right? I mean, this is why the question is interesting, right? And if there's, I mean, I clearly have not read the redacted materials in the Mueller report, so I don't know if there's more in there that would have gone into articles of impeachment, but it does bring questions about if they can't get the information, can they fully, were there more articles they would have put in had they had this information? What would the full impeachment process look like?
And the courts have even taken it further and said, if we don't allow Congress access to this information, in the future, all an administration has to do is put something in the context of a grand jury, and then Congress can never get it. So they even went further. Well, let's talk about standing for 1 minute. It was interesting that the appeals court asked for briefing on standing, and the responses from the two parties is, we think it's clear they're standing. Anybody has standing to make an application for 6E material. Even the Department of Justice said we're not protesting standing. What do you make of that from the appeals court asking for that briefing on that topic?
It's an interesting question, right? Because you're absolutely right. Both sides in this case concede that they're standing here. And in fact, standing hasn't been an issue in the other cases in which a court has been asked to disclose grand jury materials for an impeachment hearing. So it kind of seems like it comes out of nowhere. I wondered if they're looking ahead, if they're thinking not about this case, but what happens if they don't disclose the materials and Congress comes back with a subpoena. Because if Congress comes back with a subpoena, then that gets you to the whole standing discussion that they're having in McGahn, right?
Well, they did subpoena the Department of Justice before this case, but they're not using that in this proceeding. They're just asking for the application process.
Right, and what I'm saying is in the application process, it looks like standing shouldn't be a question, right? I mean, it looks like they don't have a choice except to go through the application process because these are materials that they have to have court authorization for the disclosure. So that makes me think they're thinking ahead, right?
Or could they be thinking about impeachment? As Professor Adler said, as If you get to impeachment, then hands off.
I think it's also, I mean, it's, the question of legislative standing is in the air in a way, across a wide range of cases, in a way historically it wasn't. Congress goes to court more often than it does. And so I took it as, this is coming up kind of every time it goes to Congress is coming to court, we should just get briefing on it just to make sure, because we know that, not only have we been dealing with more of these cases, but, there's some, the Supreme Court has come back to this a couple times, most recently in the Bethune-Hill case, this question of when legislatures do and don't have standing. So I think it was more just a kind, we need to ask this, and I agree that in this particular posture, the standing question is easy, but it's kind of, we want to make sure, we want to make sure we heard those arguments before brushing it aside.
Well, there are conflicting positions from some of the members of the DC Circuit on these standing things, and so they might be having an intercourt fight about it.
Yeah.
Do you see what I mean? I mean,
Yes.
because there are so many cases, just building off of what Professor Adler
And
said.
Judge Rao is on this particular panel.
Yes, so that they may have DC Circuit disputes about their positions on standing with respect to Congress, because it's a continual problem for them.
All right, let's go to our fourth and final case, the world of emoluments. Professor Adler, if you could help us out here.
We're happy to. Happy to talk about this case. And this is a case where standing, I think, really is front and center. So let me say a little bit about this case. As I think folks know, and may not have known until a couple years ago, but the Constitution does contain a couple emoluments clauses. We will not have a spelling test on how to spell emolument. Article 1, Section 9 provides that no person holding any office of profit or trust under them shall, without the consent of Congress, accept any present emolument, office, or title of any kind whatever from any king, prince, or foreign state. And this was an anti-corruption provision put into the Constitution, concerned that the United States, particularly as a relatively new, small, not particularly powerful entity, could be at the mercy of more powerful and more wealthy foreign entities. And we see this in a lot of aspects. In fact, one of the reasons we have an impeachment, one of the things the founders talked about was a similar sort of concern that the president could be under the sway of foreign governments and abuse the powers of that office in a way that ultimately serves foreign interests. There is another emoluments clause which is not at issue in this litigation, the domestic emoluments clause, which prohibits the president getting any other emolument from either the United States or any individual states. That's not an issue in this case because there is no ability for Congress to waive that prohibition the way there is with the foreign emoluments clause. There are several emoluments cases out there. There's one in the Second Circuit where there's a petition for en banc rehearing pending. There's one in the Fourth Circuit where they just recently heard en banc argument. Those involve private, one involves private litigants, one involves suits by states and the District of Columbia. The one that I'm going to talk about was filed on behalf of approximately 200 members of Congress, 30 or so senators, and I think 166 members of the House. And it raises some issues that are similar to the other emoluments cases, but are some that are distinct and that are particularly interesting, given the sorts of interests that can be raised by members of Congress as members of Congress. The underlying claim in all these cases is that the president, because of his various financial holdings, real estate holdings, and the like, is potentially receiving emoluments when foreign governments enter into leases for buildings that are owned by the Trump businesses, stay at the Trump Hotel, and so on. And that insofar as the president may be deriving any financial benefit from these arrangements, that this could be a prohibited emolument. And there are interesting questions about precisely how we understand what an emolument is. Is it something that is related to one's holding the office, or is it any financial benefit whatsoever? And there's a very interesting debate about that. In this case, the members of Congress are seeking both declaratory relief in terms of clarifying what is a prohibited emolument, and also injunctive relief prohibiting the president from continuing to receive emoluments. And so that makes this case somewhat different from the other cases we've been talking about, as this is not Congress seeking to engage in kind of traditional oversight efforts. And I think part of the rationale here is that because this president, unlike prior presidents, has not engaged in the degree of financial disclosure or other steps to remove any appearance of potential receipt of emoluments, that Congress can't simply just engage in oversight because it doesn't have the ability to do that. It needs to act more directly. And so it creates some separate issues. And the underlying question that the courts have been struggling with, and that is particularly interesting, is if Congress issues a subpoena and the target of that subpoena fails to comply, the executive branch fails to comply, our understanding of why Congress might be able to sue is that Congress is injured because its institutional power to engage in oversight necessary to facilitate its legislative power and perhaps even its impeachment power is frustrated by the failure to comply with the subpoena. And so that would be the sort of injury that would justify going to court. Since Congress isn't engaging in oversight here, the interesting question is, what's the injury? And so the claim that is made is that because the Emoluments Clause says that receipt of emoluments from foreign governments is prohibited unless Congress consents, that the president's alleged receipt of emoluments without having obtained congressional consent essentially vitiates or nullifies Congress's right to be the gatekeeper of whether or not emoluments are received. So the claim is essentially a vote nullification claim, and there are some old precedents that suggest in some contexts actions that nullify the ability of a legislator's vote to count, it could be a basis for standing. And so the claim is that that is what's at issue, and that's why this focuses on the Foreign Emoluments Clause. The district court accepted that, accepted also the claim that there is a cause of action here, which is another issue that came up. Is there, the Constitution doesn't say what you do if there's an emoluments violation. Certainly impeachment is one way of dealing with that. Congress has, with regard to the president, not enacted legislation to operationalize this. We can imagine legislation requiring actions by the president, perhaps authorizing whistleblower suits or something that might operationalize the prohibition. Congress hasn't done that. And so another question in this litigation is there even a cause of action? Can it be implied equitably from the existence of this clause, or do we actually need some sort of statute? And I should just note, this underlying question about when you imply causes of action, historically, we went through a period of time in the Warren and Burger courts where the Supreme Court was generally permissive and generally thought that when there is a legal requirement or a prohibition, we can readily imply that the courts get to hear claims. The Roberts Court is clearly more stingy on that question, and so I think one of the reasons why the Justice Department has pressed the cause of action claim or argument is because they are aware that the current Supreme Court doesn't like to recognize implied causes of action that haven't been recognized before, and so I think that's why they've raised that. But the district court included that there was a cause of action and adopted a very broad definition of emoluments to be any profit, gain, or advantage. So any financial transaction would be a potentially prohibited emolument. Interesting thing about this case, the president's attorney sought interlocutory appeal of the two decisions denying the motion to dismiss. The district court said no, and so they went to the D.C. Circuit, and something similar happened in the Fourth Circuit. And the D.C. Circuit, I think, reprimanded the district court that this should have been this, and there have been a bunch of cases like this in a range of contexts where the traditional standards for what should allow for an interlocutory appeal were met, and that district courts, for whatever reason, didn't certify. And the district court, for the DC Circuit. The DC Circuit issued what is a fairly aggressive. I don't think it would reach. I don't think it's pungent, but the DC Circuit, kind of. It understates its displeasure at lower courts or other branches of government usually. And so by that standard, it was a fairly aggressive opinion saying, look, these are just positive questions. They are clearly questions about which there is uncertainty and reasonable folks are going to differ. How could this not be the sort of thing that justifies interlocutory appeal? We won't order you to do it, but we will remand this back to you, having essentially told you what the answer is. And so the district court promptly certified this for interlocutory appeal, and we heard oral argument in December. I just a little bit on the underlying standing issue. The D.C. Circuit historically had been somewhat permissive on legislative standing. The Supreme Court less so. But there aren't a lot of cases. Right? Raines versus Byrd is the big one involving the line item veto. There is language in Raines versus Byrd that would suggest that individual members of Congress on their own have a really, really, really hard time asserting an injury, that there might be the ability, Congress as a whole, perhaps even in a committee, might have institutional injuries that they can vindicate, but individual members much harder when what they are saying is that this is something that Congress would do. But Raines versus Byrd also spent some time discussing these issues, so it's not as if there is a clear, bright line saying you can never do this. There's just a suggestion that it's exceedingly hard. There are some D.C. Circuit cases like Campbell involving war powers that might have some parallels. And then most recently, the Bethune-Hill case, which involved the state legislature, which admittedly raises different questions. An opinion by Justice Ginsburg suggesting a very high bar for individual members of a legislature or anything but the body acting as a whole to have standing. And at oral argument, this was certainly something the D.C. Circuit was very interested in. My own view, I think the standing argument here is hard because it's not clear to me how, if the claim is vote nullification, it's not clear that any of the members of Congress that are suing are guaranteed the chance to vote by winning. It does seem to me that there are alternative ways that Congress can seek enforcement of the Emoluments Clause, and alternative ways short of impeachment. And that's my suspicion of the direction the D.C. Circuit is going to go, but we will see, I suspect, sometime this spring.
Well, thank you. Another totally fascinating case that's active in the courts. We've never really had anything like this before. The first thing I want to ask you about is the issue of mootness. So this case was filed 2 years ago. The lower court took 2 years to issue several opinions, and now we're in this interlocutory appeal. And should President Trump not be reelected, the question is, how likely are the courts to rule, well, the whole thing's moot and now we're not going to decide it? And it seems like this is something that's should go to the Supreme Court, but what's your reaction to that mootness problem?
Well, I mean, if he's not reelected, then the cases, I think, this case becomes moot. I'm pretty sure, if I recall, the other two cases are also only asking for injunctive relief and injunctive and declaratory relief, in which case they would be moot too. If there were a party seeking some kind of damages or something, then that might be different, right? So hypothetically, if Congress had enacted a statute that created some sort of qui-tam or whistleblower sort of mechanism for private individuals who are aware of emoluments violations to bring suit and then collect some sort of portion of the damages or what have you, then that would be a way around that. But we don't have anything like that, so there is the possibility of this dragging out. I suspect, I would think, the Fourth Circuit has heard oral argument en banc, Second Circuit has an en banc petition. I could see certainly the question of standing related to emoluments and perhaps even what emoluments is could get to the Supreme Court before the election. I don't think the Supreme Court could decide it before the election, but it could be on the docket. But yeah, if the president's not reelected, then, come January of 2021, these cases go away.
Let me ask you about this. So the members of Congress in their lawsuit is arguing that the president is ignoring a specific constitutional directive to get their consent before accepting a foreign emolument, but he's also ignoring his duty to take care that the laws be faithfully executed. So how important do you think that factor is going to be in the higher courts, that the president is simply ignoring what the Constitution is telling him to do? How persuasive is that, do you think that's going to be to the appeals court, for example?
I don't think it helps the standing argument, and I think that threshold question is really right. Is this the sort of thing that members of Congress can go to court to vindicate? And I think, while I think that the take care claim here is a serious one, I think that if a president's affairs are such that reasonable people may suspect that the president is engaging in ongoing constitutional violations while remaining in office, I think there's a very clear argument that is in conflict with the president's oath and obligations. But I think that the issues that the court is most interested in are the threshold questions of can Congress go to court as opposed to the owner of a hotel that believes they are being unfairly competed with by the Trump properties, which is an issue in the Second Circuit and in a way in the Fourth Circuit case. I don't think that the D.C. Circuit is likely to. Certainly at oral argument they did not show a lot of interest. There was a very, very brief discussion of the merits, which is interesting, I think. I personally find it interesting, but I don't think that's what they're keyed on. And I'd be curious whether.
Andy, I saw you nodding. Do you agree with that analysis?
I agree that the standing argument is a steep climb here, and I think I would share your prediction that that's probably going to be the off-ramp here. The thing about standing rules is the court, it's saying not you, but it's not saying not no one. It's not saying it's a non-justiciable issue. If they use standing, it'll say, like with the line item veto, another litigant came along and got the ruling that the members of Congress couldn't get on their own. And here I think there are potential other plaintiffs that might be able to have an easier time establishing it, and I think that will be on the mind of the courts. I also think the idea, but then the question here is there anyone who's going to be able to remedy this if it's really a problem? If the president's really ignoring a specific mandate from the Constitution, how does that get remedied? And I think, there is potential for congressional action here along the lines of a key tam suit, where you basically, if someone has insider information about a violation of that clause, they get the ability to bring suit on behalf of, and then move forward with some sort of personal incentive. And I would, in a totally shameless plug, commend to you to read the law review article "Disgorging Emoluments" by Caprice Roberts, who I happen to be married to. That's sort of contemplating this idea, if you ended up in that place, what kind of remedy would be the appropriate one?
It's also interesting that when the Constitution says Congress has to give consent, that it's people outside of Congress that may have more of a chance of enforcing that than Congress itself. It's just kind of a wild thing.
Well, that raises a slightly other thing. Can I just say this? One of the bizarre things that's happening now is that Austin Evers at Oversight is getting more documents than Congress.
Yeah, right.
To me, that is amazing.
It's like a private
Yes.
person is much more capable of getting this than the people's body.
Hard to
It's a
understand.
similar thing, but sorry.
Which is problematic. It is problematic. The idea that the executive branch has greater obligations to FOIA than to the branch that enacted FOIA.
Yes, there's something really odd about
is
that.
odd, and
You should enact a FOIA thing for Congress, right? FOIA C.
It should inform how we understand claims like obstruction of Congress, right? In the sense that there is a fine line between good faith claims by the executive branch that are designed both to protect legitimate executive branch prerogative and kind of, a little bit of cushion, which is the executive branch, and bad faith obstruction, and the inclusion of that as an article of impeachment raises that question, as it did when it was contemplated with Nixon and when it was included with President Clinton. But and similarly here, you know, I think we all suspect that if there were laws on the books applying to the president the way they apply to other officers, in terms of disclosure and compliance with the Emoluments Clause, it's, given what we've seen, it's not far-fetched to wonder what degree of voluntary compliance with those requirements there would be.
But the problem with Congress passing a law is the president has to sign it.
Yeah.
So, and if he doesn't sign it, then you have to have the vast majority of Congress to override that veto, and you just wonder in the current environment if that's possible. Let me ask you this. Assuming that case is dismissed on the merits, and let's say the other two are dismissed as well for lack of standing, and the president is able to define emoluments as he likes and accept them in whatever way he wants, what sort of impact might that have on the balance of powers between Congress and the president? And any of you, you don't have to, you know,
I would just
make you answer everything.
throw in that, you know, I mean, the unfortunate pattern that we see in this general area is that we have a context in which a president or executive legislative relations aren't what we would like, and the Constitution perhaps doesn't directly address it or address it sufficiently, and we get through that, and then kind of after the fact, Congress then comes back and revisits and says, okay, how do we deal with that? And we've seen this with secession. We've seen this with, I mean, that's why we have a 25th Amendment. That's why we had the Ethics in Government Act. I mean, there is kind of a, ooh, that was really messy, and we don't like how that worked out. Let's make sure it doesn't happen again. Now, that doesn't do anything to cure the problem that we're dealing with now. And, you know, I'm sure I'm not the only one. I have a list of things that, like, things that it would have been really nice that there had been legislation on the books about before 2016. But the reality is, for the reasons you identify, we're not going to get likely to get those fixes until there is a new occupant in the White House, and we've learned that emoluments needs to be very high on that list.
Well, the question is, will it ever be in the president's interest? Any president. You know, some liberals like this. They think, oh, well, powerful President Trump, we'll have, you know, we'll get rid of him and have our own powerful president. So that's what I'm worried about, that no president, you know, OLC has been writing these opinions like the president is absolute immunity for a long time. He's got a lot of lawyers. And every president pushes the envelope. You know, Lincoln did it, Obama did it, Louisiana Purchase, Jefferson did it. They all pushed the envelope. And the question is, will they ever sign it? You know, I think Ketam is great. Go send that to Chuck Grassley. Loves Ketam, right? Pass that in a second, all right? But will the president sign it, you know?
Well, I think what I'd like to do now is just take 2 minutes for each of you to maybe offer some general comments about this body of case law, the emerging case law on congressional oversight. I mean, for me, when I was putting this website together, what struck me is how many judges have been involved in these decisions. It's not 1 or 2 judges. It's 15 judges on the lower side, in the lower courts, another 15 in the appellate courts, and generally they've been pretty favorable to Congress, but all of these cases are on appeal, or many of them are, and we don't know where it's going to end up so far. So I'd like to just, each person, we want to save time for audience questions, so just 2 minutes each to just give us some concluding thoughts.
Yeah, I guess I would just make the point that, you know, there are the current controversies now, which are significant and important and grave. But there's also what is going to happen after this, and it can include, you know, what are the incentives for Congress and the president after, you know, the law has sort of been reshaped or settled to a degree more after all these cases come out. But the other thing I want you to just think about is it's the classic, like, you know, bargaining in the shadow of the subpoena, right? Like, so much of the stuff that's not in court that gets resolved is resolved as a function of people predicting how that would play out in court. And so it's all those agreements get made in the shadow of what they think can happen if they don't come to an agreement. And so it's not just what the rules are and the political incentives sort of writ large in the current political controversies, but it's how is that going to actually affect a committee staffer calling an agency within their jurisdiction to say we want X document, and how is that interaction that's not really in the press at that point? It isn't really the president, in the Oval Office versus Congress, going to be shaped by the new understanding of what the sanctions will be if they don't cooperate and engage in compromise. So I think that's like a massive consequence that is hanging in the balance as we go forward. I would just leave it on that.
Well, I'd agree with Mr. Wright that these are excruciatingly important to the future of the separation of powers. I mean, I've been waiting like 20, 30 years, if you write about the separation of powers, there are like 12 cases, and, we can memorize them. Professor Adler memorized lines and all of that. But these are really huge, I think, people tend to think of the abortion cases or this, and I know that's important to real people, but this is important to real people too. It's important because over the last 40 years, we have taught people, and I include myself, but both liberals and conservatives have taught people to hate Congress. It's all broken. The Brookings Institution, how many books have they, this is liberal and conservative. We don't like that body. It's a swamp. But if you cross out Congress and you cross out politics and you put the word democracy in there, there's something really big at issue here. The president has been gaining power, according to political scientists, over the last half century, and it's gotten even worse, in my opinion, with new technology. And because it's a multiple person body, it is always going to be at a disadvantage. If you have to get, if any of you are in newsrooms or you're in faculty meetings, you got to get 100 people to agree, or 50 or 15. It's a lot harder than having a hierarchical system where one guy can tweet, or one girl. So this is a very serious time. And whether there are cases that appear to be about the emoluments clause or the grand jury or something else, I think this is just the most important time in memory in terms of the balance of power and what these courts will do. And all I've been saying since the beginning, I wrote an op-ed a long time ago, I think a year ago, saying, these cases are going to the court. I wish I had a Speedy Trial Act for courts. Speedy Trial Act says that you have to rule on a defendant's criminal case very quickly. Courts don't really like these cases. They think they know they're momentous, actually. So I'd like people and I want to thank Elise for this is a really important thing to do, because these cases will help shape day-to-day negotiations up and down Pennsylvania Avenue for whatever president. So.
I hate to just jump on a bandwagon, but I really do agree with what both of my colleagues have already said, and I don't think we can overstate the importance of these cases for our democracy. What keeps coming to my mind, and this might be because I have an 8th grader who's studying American history and studying like the framers and how did we get here, is how important these questions were then and how important they are now. I mean, it's interesting. I had someone ask me the other day, well, do you think this really matters? I mean, the framers did this 200 years ago. Do you really think we're still worried about presidential power in the same way? And I thought, no, more. We ought to be more worried about presidential power now, because there are these whole ways that the president can take on power he couldn't have done. I mean, if you think about the founding and the fact that the president really didn't have a lot of power, because there were things he was very limited in doing. Now we have a whole administrative state that he is commanding, and so I think what they were worried about, we should be very much worried about today. And I'm deeply concerned, in part because law professors and political scientists, I'm a political scientist, so I can take all the flack for this, And the media have just made Congress look really bad. I mean, I know, because I have a favorite joke about Congress, which is which is all about, you know what pro means, right? It means for. You know what con means? Against. Why do you think we call it Congress? It doesn't do anything and it's against everything. But I also think that that's a very dangerous thing to think about. And I think one of the things that scares me at this moment is that the public doesn't realize how dangerous of a situation we're in and how important these cases are. Because these are about very important congressional powers that were given to Congress for a reason, to protect our democracy from a concern that was very real in 1789, but is also very real today and very real in different ways. And unless we explore that and we help our fellow citizens understand that, we could be in a very dangerous position. And so I think it's really important, and I think you're absolutely right. Whatever new baseline they come up with, it's going to be very important for what happens going forward. And I think I'm also very saddened by the fact that, the reason there aren't more cases is because we had public officials who seriously believed that they had an obligation to negotiate and accommodate. And if we're losing that, that's a serious loss for our country. I think part of the reason the founders didn't address this, right, is because they had this belief that the branches would work it out amongst themselves. And in some ways, we should be proud of ourselves. We did a really good job for a really long time, but we should also be afraid that we're losing that. So I also want to thank the Levin Center, because I think this is highly important, and I hope we can convince the public that it's important too.
Not sure I have a ton to add. I mean, I also appreciate Levin Center putting this program together. I think, I do think there is a growing recognition that we need to think more about Congress's role, not simply in oversight, but more broadly. There are several think tanks now have programs trying to think about how you reinvigorate Article 1. Josh Chaffetz has a really excellent book that talks about the non-legislative powers that Congress has and how to think about them in their historical context. I think it's particularly important now for two reasons that relate. One, which we've talked about, which Congress doesn't do not only do people criticize Congress, but Congress, to be fair, has foregone exercising some of its powers and taking responsibility for certain actions. And up until now, that hadn't been combined with an executive branch that was really going to push the envelope. I mean, yes, the executive branch has always asserted certain sorts of prerogatives up to a limit. The executive branch now is doubled down on all of those, or tripled or quadrupled down on all those various arguments. And that combination means that the norms we historically relied upon to resolve lots of these sorts of questions and conflicts are not being observed. And that's putting the courts in this interesting position, being asked to answer questions that courts have largely been able to avoid having to answer, right? There aren't a ton of cases, especially the Supreme Court, on these questions. But for some of the things we've been talking about, even at the DC Circuit level, there's a limited amount. And one of the things the courts have to think about is to what extent are those norms that were observed for a long period of time actually the rules of the road, or were they just merely accommodations that were made in light of some underlying set of legal requirements? And that, there are very broad differences about the extent to which norms should, and those sorts of norms about the way the political branches operate should inform what courts do. The other thing that might be different now, and I don't think we know yet, I think we'll know soon, is that there has been this tendency historically that when the executive branch pushes really, really hard, it loses. Right, Morrison versus Olson. Reagan administration wants to take its shot at the independent counsel law, and they get one vote. Look at a lot of the Clinton cases. The assertion of protective services privilege, the Lindsay case, and so on. I mean, the norm in the courts had been courts weren't too involved, but when you're really pushed, at the end of the day, they tended to decide against the executive branch. And I'm not sure that that's what we will see. but I'm not sure we'll see unanimous decisions like in the Nixon case and the Jones case. I'm also not sure whether or not the executive branch loses, and that makes this a very different time to think about some of these questions in the past, and one that certainly is worthy of thought and concern.
Well, thank you for those very thoughtful comments. As somebody who spent 30 years doing congressional oversight, working for Senator Carl Levin, I'll just tell you that for me, I've seen up close the important role that Congress can play when it does oversight. There's a history of checking executive branch abuses. There's a history of identifying corporate misconduct, spending, wasteful spending, other kinds of problems with how our government operates and how the private sector sometimes takes advantage of people. And Congress really, we have a lot of examples where Congress doesn't do a very good role in oversight, but I will submit to you that there's also years of history of bipartisan fact-based investigations. I certainly did that my entire career in the Senate, despite partisan gales blowing. And it is possible, and it continues to go on today, although it is not covered very much by the media. In fact, my media friends, I said to them, well, would you go to a bipartisan hearing? And they're like, no, it would be boring. So that tells you what gets covered in the news and what doesn't. Congress needs to have informed decision-making. It needs to get facts, and we need a process where Congress can come together, people from both sides of the aisle. When I investigated, I said, if I investigate with somebody who's just like me, it's like in an echo chamber. You only really get the facts if you investigate with somebody who fundamentally has a different worldview. Because when that happens, you see different facts, you interpret them differently, you have to challenge each other to come to a common understanding of what actually happened, and then think about what you do about it. And Congress is a body that, despite having all those members, which makes it a very difficult process, it is an important process that we've had for 200 years. These cases do worry me. They worry me that Congress will lose its ability to check excesses and abuses. So that's why we've devoted our time to looking at this emerging case law. So far, the courts have gone with Congress, but we just don't know what's going to happen in the next year or two. And I think it's very important, and I really appreciate the interest we've seen from the public in these cases. And I want to thank this distinguished panel for the time and the energy you've put into these issues. It's really very important. So I think now what we want to do is open up to questions from the audience. It's very important that you wait until we get the microphone, because otherwise we're recording this and nobody will hear your questions. So I see a hand in the back. Please tell us who you are and then ask your question.
Hi, I'm Kevin Mulshine. I'm the retired Inspector General for the Architect of the Capitol and worked on the Hill for almost 20 years in the employment accountability area. But in hearing your discussion, I'm just wondering, have the courts, if the courts demur and don't decide these cases, or they don't decide them in a timely way, is there a time when Congress, either the House or the Senate or both, are going to say, we need to put the sergeants at arms to work, and whether it involves commandeering jail space at the DC jail or more luxurious space at the Marriott, which is close by, really say to these witnesses, if you don't show up with the documents, or if you don't show up, you better bring, you better have your toothbrush, because there is going to be some way to compel appearance, testimony, and production of documents.
Your question about direct enforcement by Congress is right on point, because there is actually a case where they had first put a guy in jail and then they put him up at a hotel while they were deciding all these issues. So
Willard?
comment.
It was pretty nice.
I think it
hotel.
I mean, I personally think that's a very dangerous move, especially in the context of the separation of powers fights. Like, I just don't think, I'd like to think that everyone would be de-escalatory, but I don't think it would be a good idea to send like the sergeant at arms to go try and arrest Eric Holder when he's the attorney general, when he's following an order from the president related to an executive privilege assertion. I think it could be potentially more effective with these third-party subpoenas or private sector subpoenas. But again, it's a little bit, I still have nervousness, especially with these ones that sort of relate to the president, about where that could lead. At the same time, I understand, sort of baseline frustration if it feels like the other enforcement mechanisms aren't working. So I recognize that piece of it, but I'm very concerned about that process being sort of revived, personally.
I mean, I share that. I mean, we were long past the days when that sort of thing kind of happened and was just seen as normal. And I think we rightfully worry about escalation of those of actual physical conflicts in a way that makes us not want to think about Congress exercising that power. There is something else that hasn't come up that kind of relates to that, which is I believe the statute of limitations for contempt of Congress citations, when they refer to the Justice Department, is 5 years, which means at least for a one-term president, a future administration does have the ability to bring prosecutions for contempt citations. That's not been the norm. It probably should be the norm, and I would think maybe Congress should extend the statute of limitations to 9 years, and then the issue of the Justice Department not being willing to prosecute someone from within the administration goes away. There's a deeper question about, which is endemic in all of these discussions, which is, while the founders thought a lot about faction, they didn't quite think about parties, and they didn't think about how the theory of rival ambition as a check on executive power would be compromised by partisan loyalty. And particularly given the nature of partisan divisions today, we see members of Congress being more concerned about their partisan loyalty than their institutional loyalty. And there aren't yet many, well, I guess I should say there aren't many left in the House or Senate that recognize the long-term implications of that. And so I think, apart from whether or not the inherent contempt power is used to physically restrain people, there is this, I think, larger question of at what point are members of Congress going to have seen these sorts of conflicts play out in both directions to say, not standing up for congressional prerogatives has long-term institutional problems. That, yeah, we may have protected our guy, but that also means that the next one's protected too, and maybe we need to spend more time thinking about how to maintain congressional prerogatives because they matter.
There's also a lively discussion about ways to strengthen congressional enforcement of subpoenas, sometimes within the context of the rules of the House or Senate, sometimes by passing legislation, which of course would require the president to agree, most likely. But that discussion does go on, and there are a number of people who have different kinds of ideas about having faster court processing of subpoena requests, of having different kinds of subpoena enforcement authority.
And
Do I
sorry,
have
one really quick thing I forgot. Fines. I don't feel the same way about fines. I think fines could be a good idea, potentially.
That's been discussed,
Yeah.
never tried to
Right.
actually impose monetary fines for not producing information. But I think we have a question here. We have one right here.
Hi.
Okay.
Okay. Hi, I'm Steve Katz, and I worked for Senator John Glenn on the Senate Governmental Affairs Committee, and I was actually chief counsel of the Government Information Subcommittee before that, and have great admiration for Elise as a colleague and Senator Glenn as a mentor, and thank you for forming the Levin Center and everything you're doing here today. We're clearly in very serious times. We don't just have an authoritarian president. We have somebody who believes in the rule of one man versus the rule of law, imposing autocracy instead of democracy. It is not unusual, to your comment about Austin Evers providing information or having greater access than Congress might. Back in the 80s during Iran-Contra, I actually was supplying The House ran contra side of the committee with their presidential directives from the NSC. I had, through FOIA and other means, acquired more of Reagan's national security decision directives than anybody else had. And I think if you talk to people such as, the National Security Archive, Tom Blanton, can help people understand that issue. I wanted to ask a question about executive privilege because we hear it bandied around a lot. Is it the same as immunity? And looking, Steve Ross and I were talking the other day about executive privilege in judicial impeachment cases where I told him I would raise it today. He thinks it's been waived. In those cases, does the president necessarily have executive privilege in the impeachment investigation here?
I don't know where to begin. There are textualist interpreters of the Constitution, such as Cy Prakash of the University of Virginia, who doesn't think there's any executive privilege, that the Supreme Court made it up in the United States versus Nixon. It's not in the Constitution. He's a conservative who believes in very strong executive power, but but we have a case. That's a theory. The case is Nixon, and that tells you that in that context, at least, there is a certain form of executive privilege, and there are other cases involving deliberative forms of that. But I'm not sure what the question was with respect to judges. But that we don't have a lot of case law. We don't have a lot of information, as Professor Adler has said, about what the contours are. It's been negotiated, basically. There is, interestingly enough, people understand that courts follow precedent, but the White House counsel's office also, and Mr. Wright could confirm this, I believe, follows precedent. When they don't know what to do in a situation, they call over to the National Archives and said, what did George H.W. Bush do? What did the other party do? To try to find a precedent, because they don't have any other than the OLC opinions, which tend to be pretty on the pro-president side.
I'll just follow on and say, I think executive privilege is a valuable and important concept and doctrine, and I think it's valuable to presidents to be able to have that, to have a vehicle by which to assert executive branch confidentiality interests in a way that has some legal definition and contour, and that can raise them in the context informally with Congress or with other judicial proceedings, but that has varied exceptions and sort of expectations about when it might apply and doesn't apply, and the fact is that there's the political costs of onboarding and assertion of executive privilege, of looking like you're stonewalling, which sometimes is true, and sometimes that characterization isn't as true, but you're generally going to have, if you're Congress or the other requesting party, you're going to have common cause with the media because they share the information, interest in information being disclosed. So I think it is a valuable and important doctrine. I think that can be abused, and I think and we've seen some examples, some of which have been stark, where it has been abused. But I think waiver or de facto waiver, and not being able to shield misconduct, or there's a lot of types of things that I think eat at it, and I don't think it's certainly not a categorical, like immunity, where you just get to sort of say no, I'm not going to answer anything within the scope. If you've released a transcript of a call, you're probably going to have to talk, allow people to talk about that call. If you've got an OIG, as the court ruled in the Holder case, if the IG has released a big memo containing executive branch cooperative produced documents, then it's going to be hard to say that anything that wasn't within the four corners of that can now be held back as privileged. That it weakens it. Same thing I'd say probably with the Mueller report. And the sort of areas around that. So I think it's an important doctrine, but that can be abused, and I would hate to see it just be sort of invalidated wholesale.
Well, I don't think it would. By the way, I don't think it would be. Every president since George Washington has asked for some secrecy, because you literally can't do the job. And by the way, even though I'm very critical of this current president, my experience in the White House was that it's extremely highly regulated if you follow the rules. If you try to follow the rules, it's hard not to commit a felony.
Sorry, one last little point too, which is
I don't
that
think we want to explore that. Right?
No.
no. But relevant to the impeachment question, the arguments for executive privilege in the impeachment context are weaker, but I don't think they're non-existent. So, for example, let's say that nuclear codes or a particular name of a U.S. asset in a foreign country, say Russia or Ukraine, that's helping the United States or something on that level, I think there's certainly an appropriate executive privilege type of claim to be made that should operate in the context of an impeachment inquiry. But it
And
would be
perhaps
very
a
narrow,
whistleblower's
I
name
think.
as well.
Yeah.
I was gonna, I think, while the Constitution doesn't mention executive privilege, the idea that it exists has been around since the beginning. It's talked about in Marbury versus Madison in the oral argument. If you accept Cranch's reporting in the oral argument in Marbury, Chief Justice Marshall says, and asking a question, and says, if this is confidential, then you don't have to answer. And so the idea that there is a presumptive privilege exists. But the other thing that we know, going all the way back to President Washington, when people were upset about the Jay Treaty, and Congress wanted documents, and Washington's response was no. But if this is actually related to impeachment, like I don't think you're going there, but if you are, then I will have to turn it all over. So I actually believe that the norm and the way we understand the power is that there is no executive privilege in impeachment, and just like the speech and debate clause has no limits, if Congress puts impeachment on the table, I think the proper answer probably is any claim of executive privilege goes away, and the president has to make a political case, as I think this president has done. I mean, I think a lot of the documents and things that look legal that the White House has put out are really better understood as political documents, right? It's a political case to try and get Congress to not exercise what is ultimately an incredibly powerful tool. But I would argue once you're in an impeachment proceeding, executive privilege claims should go away.
Another fascinating topic that we should perhaps have an entire panel on.
Good morning. Thank you so much for this wonderful panel. I teach Congressional Oversight in the fall at Georgetown Law. Wish we'd had it then. But my original question was going to go to the good governance recommendations with regards to modernizing inherent contempt, and you touched on that, the fines. So I'm going to pivot to my second question then, that goes to Congress's ability to enforce its informing function. And so there was discussion with regards to the emoluments cases, but what about like the 7-member rule case that ultimately got mooted out because the Democrats became the majority and the court said, well, you can just subpoena them. But again, there have been court decisions that said, yeah, there's a statutory provision that allows you to request it, but there's no mechanism by which you can enforce it. So what are your thoughts about that? I wasn't trying to stump you guys.
Congress has not had to think as hard about that historically as it does now. I mean, is the bottom line, right? In the sense that we, in a lot of these contexts, we kind of assumed that everyone recognized that this was an iterative game, that your team is on one side at one point in time, but will likely be on the other side at a future point in time, and so therefore conforming to a relatively, to a range of norms or a range of kind of postures was the right thing to do. We have lost that, at least for the time being, and so the need to have more formal mechanisms for enforcement is something that has to be thought about in a way that we hadn't had to think about it before. I think that's the underlying point. Are there limits on what Congress could do effectively? Perhaps. I'm not sure entirely what the contours are. I mean, might Congress have to be really clever about how to make fines self-enforce or yourself make them operational without executive branch cooperation? Yeah, it might. And could it do that? Are they things that automatically get, do they automatically count against tax refunds or tax credits? I mean, there are other things Congress could do to not be dependent upon executive branch cooperation or enforcement. Probably yes, and we have to think about that in a way that historically we didn't have to.
That stat, oh, sorry, go ahead.
I was just going to mention, if you look on our website, we have a little section under key issues called Oversight History, and these are sort of comments by the courts looking over the years. And there's one comment that we've never had the kinds of arguments that are being made today in 200 years, and therefore history doesn't help us a lot in deciding some of these claims.
I was just going to say that, for those of you who aren't like, totally on top of this, the 7-member rule is a statute in the House, that allows, basically provides the minority party with a mechanism to have something under a statutory scheme that could issue something approaching a subpoena. And the theory being that it would empower the minority to not have to get the chair and the majority to sign off on certain types of requests. And it got mooted. And I think it presents very complex legal questions and justiciability questions. And if Henry Waxman is watching this, I'm not going to speak ill of the statute, but I think we really don't know the answer about how that statute would actually be perceived by the courts, even notwithstanding that original sort of push.
Yes.
Morning. My name is Richard Golden, Wayne Law 71 for Mr. Wright. You mentioned fines.
Yeah.
If a fine is imposed, what do you have? Do you have a judgment? Is it writ of five-fay? Who's going to enforce it? I think there's physical jurisdictional limits on the sergeant at arms as to where he can enforce the writ. If you have a fine and the judgment debtor is in another state, what is the mechanism?
Yeah, so I do not have a good answer for you on that. I think, so I apologize for that. I think that is the kind of thing that would need to be ironed out by the folks if Congress really decided to establish some rules or legislation grounded in its inherent contempt authority, which would be the basis of it to engage in that action. They would have to work those things out about how would it be like a garnishment where there's sort of like you just take the application and that you try to avoid bank or like court involvement until there's putting the burden on the person on the other end. So I think those are the kinds of things that I think Congress would want to fashion those rules in the ways most advantageous to Congress. But all that would have to get worked out by the right experts. I think it's a very good question.
I'm Margaret
Could you
Taylor.
please stand up,
Sure.
just so I can see you better?
Margaret Taylor. I am a senior editor at Lawfare. I cover Congress's role in foreign policy and national security issues. I'm also from Brookings, so I'm one of those people that Professor Nourse was talking about earlier from Brookings who works on congressional issues. My question is a little bit maybe the flip side of this, which is, so it seems like, just as an example, in the current environment, members of Congress and maybe Congress institutionally are willing to sort of stand up for some of the president's constitutional prerogatives, right? So we see Senator Johnson yesterday saying, well, the president's power of executive privilege is very important and we need to protect it. My question for all of you is, what do you think of the flip side? Do you think there's a responsibility on the part of the president's lawyers, to take into account Congress's constitutional prerogatives in pursuing vigorously their client, the president's goals? So because what I'm seeing is the president and the president's lawyers aggressively pursuing the president's constitutional prerogatives, seemingly without very much regard for Congress's. So I'm interested in your views on whether there's that duty, or is it really just lawyers vigorously protecting their client without regard, basically, to sort of any other constitutional prerogatives of other branches?
I think it is important for the starting premise to be, if you are in White House counsel's office, or if you are in OLC, or if you're in an agency, in GC's office or Leg Affairs office, to start with the premise that Congress has legitimate interests in information in order to do its job, and that is constitutionally grounded, as the Supreme Court has said, and how Congress has also articulated, and how the executive branch in some of its own doctrines has recognized, and some of its own correspondence over the years has recognized, and OLC has recognized. They might not have, come as strongly on the point. I think that's an important starting point. And so I think it's not just they're not entitled to kind of starting point. It is a what are the interests and what are our concerns about in the executive branch about information, and how can we get to a point where everyone can come out in a good place. I think Congress finds that greatly distressing that the executive branch would have the temerity to say, well, yeah, we'll refashion your question to give you things we think you need rather than what you told us you need. And that's a constant source of tension. But I do think that the starting premise is that there should be internal advocacy to a degree about the legitimacy of congressional inquiry. I mean, if you're investigating the Benghazi attacks, Congress has a right to look at that. I'm not sure that they have a right, or should go some of the directions you might go with that investigation, but it's certainly within Congress's interest at the baseline to go look and see what happened at this terrible incident at U.S. diplomatic and intelligence facilities overseas and get information about that. So I think you have to start with that. So I think that should be happening internally.
And I think more broadly, when the president and other officers take office, they swear to defend the Constitution, and the Constitution has this three-party system for checks and balances and separation of powers. So I think there is a basis for every executive branch official, just like every member of Congress, you're defending the Constitution and the system set up.
And I think that's a really important point that you're making, Elise, because that's what I was thinking about when Mr. Wright was speaking, was it's not just that should be a premise. I mean, that's what the Constitution tells them to do. I mean, they have an obligation. And I think what's disconcerting about some of the arguments that are being made is that it's not just that it's an assault on congressional power, but it's on constitutionally mandated congressional power, and it suggests that there's a disregard or a misunderstanding of how our system is supposed to work.
And on both sides of Pennsylvania, I mean, it's happening in Congress as well as in the White House. Yeah.
I was going to say, I do think that, and this has been hinted at already, that some attention has to be played to which lawyers are we talking about. What we expect of an attorney in the Department of Justice is different than what we should expect of Will Consovoy, who's representing the president in his private capacity in court. And there are arguments that I think it's perfectly appropriate for Will Consovoy to make in court that would not be appropriate for the Justice Department to make. And in some of the cases, we've actually seen the Justice Department taking slightly different positions than were made on President Trump's behalf as Donald Trump. I think the question gets a little interesting when you talk about the White House counsel's office, just given the somewhat unique nature of that office. But I do think, in general, government attorneys in the executive branch have an aspect of their obligation is institutional, not personal, and that should inform the arguments they are willing to make consistent with their duties. And I think it is fair to observe that those bounds have been under strain of late, and that what we believe is acceptable, and in some cases even obligatory in terms of zealous representation of clients in certain contexts, has to be viewed differently when we are talking about executive branch attorneys, and should be. And there are obligations to the branch and to the institutions that those attorneys have that a zealous advocate as a criminal defense attorney or what have you does not.
I think we have time for one more question.
In the discussion about the fine, I was thinking about what's your view on Congress using the power of the purse to zero out? For example, if Mr. McGahn was continuing to work for the White House, we've seen that Congress can bury provisions in appropriations law that could specifically address his pay and zero it out, either conditionally upon his appearing or just simply eliminating his position.
So the courts have talked about that, and they've also talked about how you need the president to sign that bill, and that appropriations bills often take a year to get done. So that is a problem as well if you are trying to get something done on a timely basis. So, well, I mean, that's interesting because in some of these cases, they're acting within weeks or months, but sometimes they're taking 2 years. So you're right about that. And it certainly is an available tool to Congress, but it's not a particularly effective or one that you got to get through a lot of steps to get there. So, okay. I would like to welcome Jim Townsend, the Levin Center Executive Director, back to the podium.
Well, thank you, Elise. I better wait. Well, thank you, Elise, and I want to start by thanking our panelists for a wonderful conversation, a wonderful discussion about some really, really important issues. I want to say a few things before we close and then thank a few people. First of all, I want to say what I should have said at the outset, which is that Senator Levin really regrets that he could not be here today. He, as much as anybody, understands and grasps how much this means, how important the conversation we're having here in these cases will be to the future of congressional oversight, to the future of our separation of powers and checks and balances. And if he were here, he would definitely say that to you. I thought the conversation was incredibly insightful and pungent, in the very best sense of the word.
Our favorite word today.
Not only were the opinions cited very pungent, but I thought the opinions of our panelists were quite pungent. And I think we made up a new word. Elise, I think, is groping toward it with FOIA-C. I might call it FOIAC. Who knows? We might have a new word to be working with. I'd like to take the conversation back to really the beginning, at least from the perspective of the Levin Center, and that is that we're here talking about a dozen cases when there haven't been a handful in the history of the country leading up to this time. And the question is, how did we get here? And I think we've drawn that out here in talking about the breakdown of the norms of Congress, the ability of Congress to actually operate functionally, to be able to actually get things done and be able to negotiate and accommodate. And of course, what we're seeing now is a loss. That pattern has gotten so severe that it clouds the picture when we think about what the court's options are in terms of off-ramps that it might choose, opportunities it might take to rely on Congress to work with the administration and negotiate and accommodate solutions to these kinds of disputes. I want to say about the underlying cause of this, though, is that we're really talking about political polarization that is strangling our capital as well as many of our state capitals. And I want to just bring you one example of why this matters so much, and one reason that we care an awful lot about this, to have a panel like this, but to also be doing other work the Levin Center is pushing to try to do something about political polarization and the way it's really strangling our democracy. I am a former congressional staff person, but also a former state lawmaker. I was a member of the House of Representatives in Michigan. And everybody in this room is familiar with what happened in Flint, Michigan, just a few years ago to the water supply. But what most people don't understand is that was a failure of oversight. It was a failure of legislative oversight because the decisions that were made to change the water supply, to do so in a way that was not proper and that poisoned thousands of people, that decision was made by an unelected emergency manager who was given his authority by the state legislature. That was a bill that I personally voted against, but the important part is that I was a member of the House Oversight Committee in the years that followed. And the legislature, even though that city, the city of Flint, was cycling through an emergency manager every 9 months, there were no oversight hearings to see how that emergency manager law was being implemented. And had there been, we would have seen potentially people from the Flint community coming forward and saying, you know what, we're bringing jugs of brown water to City Hall and nobody's listening. Or maybe we could have had a hearing that might have occurred before the decision was even made to shift the water supply. So I bring that example forward to you to just ask you to bring that to everybody you talk to. because this is not just an abstract discussion about what goes on in Washington, D.C. This is a discussion that can affect the lives of Americans all over, people all over our country, and it can be life and death decisions. So I wanted to just bring that to you, and finally say that this is, the Levin Center's work is about restoring accountability to government, and oversight can be an awfully important part of that. It is the key to that, but also to restoring bipartisan respect and comity that is essential to actually making decisions and moving things forward. And that is a big part of what's been lost and what we need to be recovering here. And so I appreciate the opportunity to have this panel to bring some of these issues to light. Finally, I want to thank not only Elise Bean for her incredibly hard work in putting together this program and putting together the website. I also want to thank Emily Van Bar from our staff, who worked very hard to put a lot of this together and make this possible. And finally, I want to ask you to watch this space. The website, oversightcases.com, is continually evolving and continually updating the information as these cases move forward. So we hope you will come back to it. And with that, I want to thank you all one more time, thank our panelists, and hope you have a very good day.